Yes.
My restoration application.
I'm on Thursday, Mr.
That's
Yes.
Hello, may I trouble your lordships once more with the matters I mentioned yesterday? I believe they have come.
Please mention on Thursday. Call the list.
Number one.
appear for the petition. Your lordship appeared in the matter as the counsel in as petitioner's advocate. Lordship.
You are for the petitioner?
Petitioner, Lordship. And may I be permitted to hand over the order, Lordship?
No, no. I passed any order? No.
In initial order, Lordship.
Oh, on personal ground of one of us. Bole our the matter stands released from the list. Let the matter be placed before the Honorable the Chief Justice for assignment before the appropriate Honorable bench. It will. This is after order, Judge. You order?
In this matter, I have two matters. I for the Office of the Accountant General for response 6 and 7. It was referred to mediation center, but so far my knowledge runs on.
But is it our determination?
Or it was WPST.
It is WPS.
Yes. WPST
It has
one.
not. You are for the respondents.
It was number 6 and 7. Office of the Principal Accountant General.
So who is the petitioner?
My lord,
The file got lost.
Prantik Ghosh.
Prantik Ghosh.
Yes.
What was the last order passed in this?
My lord,
Order sheet to reconstruct proceedings.
it was referred to mediation center.
It was referred to the mediation center. Then what happened?
My lord, 3 or 4 sittings were there, but no partition. That's why
There was no mediation. Mediation failed.
failed.
Eh?
Mediation failed.
Mediation failed.
Matter referred to mediation. Lord
Take your breath.
Deepchani Metro was appointed as a mediator.
Mediation departmental mediation has failed.
Claim between two wives. My lord.
Is the reconstructed. Right.
But I have given all the papers. Lord, the matter, Lord, the case record.
We are placing it. We are accepting your reconstruction. We will record that mediation has failed and matter will be listed.
And I complied with all the formalities in reconstruction process by providing the papers.
Order sheet, Xerox copies. and
Everything, Lord. Copy of the writ petition and the order sheet. Everything I have provided.
Instruction was transmitted. Then if the file did not reach the mediation center, how did you sit before the mediator?
Lord, the According to me, my lord, the file reached there. Thereafter, mediation completed, mediation failed. From there to here,
After mediation failed, was there any order to that effect that
No.
mediation has failed?
no, my lord. But we were informed the mediation failed.
Who informed you?
The mediator, because the last sitting, the
Who was the private respondent?
private allegedly claims to have the second wife.
So she did not appear.
She appeared in presence of everybody, all concerned, my lord, the mediation taken up all 10 meetings. 10 meetings, but in all the meetings, mediator has done excellent job for reconciliation. Due to, my lord, the ignorance of the, my lord, the private respondent, matter could not be decided because she accepted the larger portion of the service benefit. So that is why
Now, who appeared for the private respondent?
private respondent, my lord, the Gautam Mishra. Just now, my lord, I have informed him also.
You have informed.
Yes, today, my lord, morning I have informed.
So it has to be heard now. Mediation has failed.
Yes, my lord.
By an order dated, by an order, by passing an order, the Honorable Coordinate Bench of this court referred the matter
20th September.
to the mediation center to get the dispute involved in the petition resolved through mediation. But ultimately mediation failed. However, the file which was placed before the mediation center has misplaced. Then the process was undertaken to reconstruct the file. The learned advocate,
Mediation
Uh,
failed.
the learned advocate appearing for the petitioner has submitted all the papers duly authenticated by him for reconstruction of the file. Have you checked? Have you checked?
Yes, my lord. Yes,
You?
I have not checked, my lord. I have not checked. I've checked, my
I
lord,
can
but
check it
not
out.
visible.
All-
We have tried, my level best, my lord, not available. Matter was sent to the for
One
mediation.
more
There,
learned advocate appearing for the private respondent and Union of India.
not in your
State government.
principal accounts, office of the principal accountant general.
Number 6 and 7.
6 and 7.
Testimony number 6 and 7 have conjointly submitted that they have checked the documents and the pleadings submitted by Mr. Thor,
For reconstruction.
and they have been satisfied about the authenticity of the documents supplied by Mr.
I could not check, my lord.
You check,
I'll check it.
check.
Petitionটা xerox করে
In view of this fact,
শুধু একটাই তো
list is directed to complete the all procedure for reconstruction of the file. And after completion of this reconstruction, to place the authenticated and certify, to place the reconstructed file us before us for enlistment and its final hearing of enlistment and final hearing of the. As explicitly-
My lord, kindly consider one thing, Lord, the kindly direct the department to, Lord, the conclude the everything within a certain period of time and let the matter be listed on urgent basis because I'm harassing, Lord, for long time due to non-availability of the file. Lord, I have also the suffering from the various old age ailments, Lord, I am not able to, Lord, get the pension.
Since the matter is regarding the family pension, my lord, and the retirement benefit.
Matter relates to, Lord, the family pension.
ওরা তো একটা ইয়ে করে দেবে, একটা স্ট্যাম্প তো মেরে দেবে কিছু একটা নাকি? ঠিক আছে, আপনি আবার পেন পাঠিয়ে দেবেন।
Liberty to mention or ask?
সেটা
My lord, matter will come up.
টাইমটা এক্সপিডিশিয়াস ওটা কেড়ে দিয়ে, আচ্ছা লেস সাচ exercise be completed within 15 days, within 2 weeks from date,
My lord.
and list the matter for further consideration. 3 weeks since.
Great looks.
Yes, next.
Under the head of hearing, my lord.
Under the head of hearing.
But I am for the petitioner in this matter.
Hearing এ বলো।
My lord, I am for the respondents.
You're for all the respondents.
For my lord, all the respondents, my lord.
The petitioner had retired from service on 28/2/2007. But before that, he was medically boarded out for unfit for further service. Page 46, Lordship kindly see the order of the medical board. The above named staff has been examined by a medical board. He is a case of right side.
You submitted the application on the date of retirement.
No. Tribunal has recorded a wrong finding. If your lordship see page 46.
Now you have already retired.
Now, immediately after the medically boarded out, just 2 days after I made a representation before retirement.
For what? For voluntary
For
retirement?
declare me as a medically boarded out employee and to consider the case of my son for compulsory appointment. That I have done before retirement. But tribunal has recorded the findings that I have made an application on the date of retirement date. That is totally wrong. If your lordship see page 46. The medical board has declared me unfit for further railway service. Page 46 of my writ petition. The above named has been examined by a medical board. He is a case of right side hemiparesis with residual power grade IIB, both right upper and lower limb with DMA and hypertension. He is not responding to treatment. There is no chance of full recovery. He is declared unfit for further railway service in all categories with effect from 19/1/2007. After that, immediate 2 days after I made a representation, page 47. And thus you kindly come to page 47. Just 2 days after I made a representation on 23/2/2007. But tribunal has recorded the findings. I have,
But you continue till the date of your superannuation.
but they did not consider. The tribunal has dismissed my application on the ground. I made a representation only on the date of retirement. It is absolutely wrong, madam.
It was received. You made
Before-
presentation on the 23rd February 2007.
7.
They received on 28 2007.
No, on the same date they have received, madam.
No.
26/2. Kindly see. Left hand side. Their receipt is there. And they made a wrong statement before the tribunal that I made a representation 28 February 2007. On the basis of that, tribunal dismissed my application. And there is a railway board circular also.
Were declared invalidated.
Yes, madam. Kindly see page 46.
That was on 19th of January 2007.
Yes, with effect from.
Now, what is the rule?
Rule lordship, kindly see the railway board circular I have enclosed. If any person is medically boarded out on the ground of unfitness,
No, we
Can-
have to hear it then. There is no scope for any.
yes, madam, let them file affidavit, no problem.
My lord, he had made a representation on
You file
20.
your affidavit upon
As your
hearing
lordship.
the learned advocates appearing for the respective parties and considering the materials on record. We are of the opinion that the matter needs to be decided upon. Reply rejoinder they filed.
Yes, I have disclosed.
Then do you want to use opposition to this?
My lord,
তাহলে এরকম লেখো hard Mr. Das, learned advocate appearing for the petitioner, is learned advocate appearing for the respondents, prays for leave to file an affidavit in opposition to the evidence or stop. Let such affidavit in opposition be filed within 2 weeks.
3 weeks, my lord.
3 weeks reply thereto, if any, be filed within 2 weeks thereafter. Stop. The parties would be at liberty to mention the matter for final hearing after expiry of the period as fixed above towards exchange of evidence. Yes, next.
Deeply obliged, my lord.
এরকম হাতে আছে।
Fourth.
I'm appearing in behalf of the appellant. I'm praying for a short passover. In this matter, Mr. Devendra Narayan Rai is appearing. He is in his leg before courtroom number 235. I'm praying for a short passover.
I am for the respondent. I am for the applicant respondent. Number one,
What is the matter?
my lord, an interim order has challenged before this tribunal, the passed by the Central Administrative Tribunal. They have challenged the order. By this interim order, my lord, I was allowed to participate in the examination. They say that the matriculation, my lord, I have obtained from the Chakraborty University. That is not the recognized board under the, my lord, as per their notification. My lord, the court has directed, my lord, on my lord, Monday is the fixed for final hearing of the application before the tribunal.
I'm praying for passover, my lord.
And the OA application, the interim order they have challenged, the final hearing of the OA application is pending, fixed on 12th of February before the tribunal.
Why you have
Actually, I'm praying for a short passover. only.
wait for something?
Good.
I am for the petition. Common judgment was passed by the Central Administrative Tribunal. One appeal was I filed, my lord. Two is affirm not yet final. I am praying for 2 weeks. 2 weeks time.
My lord, may I make a request?
Item number?
My lord, may I make a prayer, my lord? Item number 5 with regard to. I am appealing for the respondents.
Yes.
My lord, on 8th, it may be taken. If not, it is
It
possible.
will appear after 2 weeks, Mr. Singh. Yes. Same. Who is 6? You're 6.
I am for the
You're for the petitioner.
I'm for the respondent.
You're for Union of India.
Yeah.
You're huh?
Yes, my lord.
From this side. Please go there.
I am sorry.
Yes.
My lord, here is the affidavit of service and the track report is also there. Your lordship
It-
wanted to see it. Any.
Yes. What you are challenging?
My lord,
Which order you are challenging?
my lord, the
19th of
Last
July.
order, 19th of,
July.
yes, my lord. That order was challenging because, my lord, the review application was filed as MA something like number here.
That
That
is not
was
a
That is
review.
not review, your lordship.
a
That was
review
not-
order.
That was a modification application, in fact.
That's true. That order 480 of 2021,
Four,
page lordship 130, the last annexure.
last four,
Yeah, that is the order, original order that has annexed.
what you are submitting, which order are you challenging?
Lordship, I am challenging the order passed in, my lord, MA 480-2021. That order I am challenging. The date is, my lord,
19th July.
19th July.
19th of July, 19th of July. That order I am challenging. And in that order, lordship, the latter one in order was passed relating to the contempt.
Yes. Show us the 15 July 2021 order. That was when the original application was.
Yes, your lordship.
Yes, yes.
It is on page number 59, your lordship.
59.
Your lordship, they have not challenged this order, the order of original application. They have only challenged the order passed in MA 480.
MA 4.
480, that is the modification they have prayed for in
Tell us that this order was in 2000,
this order has been passed in
2007.
21. No, your lordship, the matter is of 2017. The order has been passed on 2021,
Where do we
15
find
July.
that? Where do we find that?
Page number 59, your lordship.
Page number 59. Date of the order is which date?
Date of the order is 15th July 2021.
Where do you find that date?
That
Page-
is page number 59. They have, oh.
Where is 15?
15th of July, my lord, 2091, that the original application order was passed.
59 तो इसका है। Okay, page number 59. That's what I've given.
One 1132 of
By
2000.
order dated 22nd November 2017, the respondent number 6 was directed to consider and decide the representation of the applicant.
Yes, your lordship. That is the first round of litigation that has occurred there.
Where is the
Thereafter-
15 July order?
15th July. 15 July is page number 59 is marked in my in his petition, your lordship.
Where do you get the date? Page 59.
15th of July 2000.
15th of July 2021 is given in the head, your lordship.
Why it is not telling with us? Page order.
It is their petition, your lordship.
Where is the
It
date?
is, my lord, it is the last annexure, the
The
original.
last annexure is 19 July, which you are challenging.
Yeah.
15th of July.
Page 84.
They have marked page 59 in our petition, your lordship.
No, lordship. They have not marked the
Oh, they have not marked the page. Acha.
15th of July. 15th of July. It's there. Lordship will kindly see the page 84. Not 59, it's page 84. that I have marked.
Original petition তো পেজ নাম্বারই দিয়েছিলেন আমরা তো নিজেদের মতো পেজ নাম্বার
When did he expire? He was removed from service by an order dated
Mirror 13th December 2005.
He was removed from service in 2005. He has expired in 3rd of June 2010.
13th
13th of December 2005.
was the
Date of removal.
date of removal. All right. Now he expired
On 3rd of June 2010.
3rd of June
Tropical
2010.
Hospital. In Tropical Hospital, Your Lordship.
Now thereafter you submitted application for retirement benefits.
No, the applicant has already died. I'm claiming for family.
No, you
No,
approached
no, the employee has died, Your Lordship. I'm asking for family pension.
when you first filed the application
Yes,
in
Your
the
Lordship.
year 2017.
Yes, Your
That
Lordship.
was filed by whom? You filed.
Why?
The wife has filed, Your Lordship, not the employee.
But that was not considered, and hence he filed
And where is the MA application? Yes. Yes, what is the wrong with this order, sir? The original, the order by which that 15 July 2021 order was not challenged by you. That has attained finality among the parties.
My lord, I am
The
challenging.
court became functus officio. Now you want to modify the order, you're filing it after how many years? When
Then and
did
there, my lord,
Uh-huh.
within a very short time. My lord, MA application was filed on, my lord, 22nd of September
Very
2001.
good. What
Order
was
was
your-
passed on 15th July. And my lord, the MA was filed on, my lord, 22nd of September 2021. Immediately after that.
22nd September 2021.
Yes.
Very good. Now, what was your ground in the MA?
Lordship will kindly see the MA application itself.
Mhm.
Lordship.
Yes, that is page 91.
Yes.
No, this ground of unauthorized absence, this ground was not taken by you when the hard application was taken.
No, sir. No, my lord. It was taken. The documents were produced before the learned tribunal, but that was not considered. There is no whisper in the
That was
document.
considered, Your Lordship.
So in that case, you ought to have challenged that order. You have not challenged that order. How can a coordinate bench
My lord, I
modify?
have stated the my lord, the challenging the order, the my lord, the further modification on the stating all these facts.
Maybe, but suppose we pass an order, you don't challenge our order. Suppose after 4 months you come and say that please modify your order because
Actually-
these are, for that you ought to have filed a review application, not a modification application. You cannot re-agitate this in a modification application.
Well, that was done. I just can't help my position
Hmm?
to it.
Show us your prayer in the modification application.
Merciful, can you see the prayer?
To modify, recall the order dated. It is not a case that it was hard in your absence. Order was delivered in your presence.
That's true. That's true.
So there cannot be ground modification you are seeking on grounds which you ought to have taken in appeal.
Milord, in the modification application, Milord, the reason and the grounds taken for modification of the earlier order of
Those are
15%.
grounds of appeal, sir, not ground of modification. The present writ petition has been preferred, challenging an order dated 19 July 2023, passed by the learned tribunal in an application for modification of the earlier order dated 15 July
2021.
Passed by the learned tribunal in an application being MA 480/2021, filed in connection with an original application being OA 1138 of 2018. Stop. By the order dated 19 July, by the said order dated 19 July 2023, the learned tribunal dismissed the application being MA 480 of 2021 and passed passed a direction towards issuance of notice to the respondents to file their show cause in connection with the contempt application being CPC/87/2020. Mr. Nayak, learned advocate appearing for the Union of India and its functionaries, submits that the learned tribunal did not take into consideration the fact that the husband of the respondent hearing was rightly removed from service as he was inter alia on the ground of unauthorized absence for a substantial period of time. Stop. The substantial period of the husband, the respondent's husband was an habitual absentee, and in consideration was an habitual absentee, and all steps were followed, and such fact, habitual and such fact was taken into consideration while issuing the order of punishment on 15th of order of punishment on 13th of December 2005. Such argument as advanced were glossed over by the learned tribunal, and no finding was returned on the said issue. On the issues on the same such infirmity warrants in the appearance of this. The learned advocate, such and such learned advocate appearing for the respondent submits that the respondent's husband, while working as a safaiwala under the railways, was removed from service by an impugned order dated 13th of December 2005. Illegally and without furnishing appropriate reasons. Furthermore, the such cryptic order was interfered without reason. Stating such facts, the respondent initially filed an original application being OA 350/01/341/2017, which was disposed of by an order dated 22nd, praying for. কি লিখলেন? তার আগে? না, তারপরে stating such facts এর আগে আরেকটা দিন। The respondent's husband ultimately expired on 3rd of June 2010. Accordingly, the respondent submitted a representation to the authorities for disbursement of the retiral leaves, for disbursement of the pensionary benefits. As such claim was not considered, the respondent was constrained to prefer an original application being OA 350/01/341/2017, which was disposed of by an order dated 22nd November 2017, directing the competent authority to consider and dispose of the respondent's representation. Pursuant thereto, an order was passed
19th April 2018.
on 19th April 2018, which was assailed in the original application being OA number 350/01138/2018. Upon contested hearing, the learned tribunal quashed the order dated 19th April 2018 and directed the respondents to disburse the benefits of family pension, gratuity, compassionate allowance, and other financial benefits. About 2 months thereafter, the said order dated 22nd November 2017 was not challenged by the petitioner's hearing. Instead, they filed a modification application about 2 months thereafter. The learned tribunal, upon considering the same, considering the said sequence of facts, rightly dismissed the modification application. Heard the learned advocates appearing for the respective parties and considered the materials on record. Indisputably, the original application being 350/01341 of 2017/2017 was disposed of by an order dated 15 July 2021. Original 350/01138/2018 was disposed of by an order dated 15 July 2021 upon contested hearing. Stop. Contested here. The said order was not challenged before the higher forum, and as such the same attained finality. Considering such fact and perusing the grounds taken in the modification application, which at best could have been grounds in an appeal, comma, dismiss the modification application. Stop. We do not find any infirmity in the said order, and as such no interference is called for. The lead petition being such and such is accordingly dismissed. There shall, however,
Obliged.
yes, next, evidential service file.
Yeah, please.
I appear to the respondent. Witness Indrani Chakraborty.
Well, this application has been filed against the order dated 10th May 2023, passed by the Honorable Tribunal, Central Administrative Tribunal. Well, there are three round of litigations were there. May we permit to place the first litigation? If you love series, kindly come to page 20 of the petition. Actually, petitioners were working as porter. Subsequently, they found in the notice board that they have been selected for the post of commercial clerk and ticket collector. And pursuant to that notification, they were asked to attend the training. They completed the training. Thereafter, they didn't get provided any job. Now, thereafter, this petition was filed. Page 20, this is the order passed by the Honorable Tribunal. Page 20.
That means that thrice the matters were sent back for reconsideration.
Yes, my lord. Yes, my lord.
What is
Difficulty is,
wrong?
my lord, actually there was an allegation that the documents which were produced, that is not the original document, fake document. That is their allegation. And pursuant to that, my lord, assumption, there was a speaking order was passed as per the Honorable Tribunal's order, my lord. There, my lord, the Honorable Authority, my lord, page 25. The pursuant to the order passed by the Honorable Tribunal, Mr. S. Bhattacharya, Chief Personnel Officer, passed the speaking order as page 25.
That is 22nd November 2013.
My lord. My lord.
Then thereafter you challenge that.
My lord, thereafter I challenge it because, my lord, Lordship kindly, for a moment I can, page 26, if I may permitted to read it. Page 20, not page 25, page 26. Both I can read, but this is, my lord.
File your paper books. There is no scope for any.
As you love, say, as you love.
Thank
My lord,
Just
thorough
that
hearing is necessary.
Lordship, my learned friend is not added, put in the rejoinder. Reply is not in the, you put it in.
Achha.
It's not an ex.
Take them.
Yes, all the
Yes, yes,
pleadings,
all of
Lordship,
it. Yes.
all the
No,
pleadings
it
should
is
be
very
put.
good.
You want any affidavit for this stay application? Not
This is
necessary.
totally a case of fraud. I think if the pleadings are there, I mean, the order, this order is very clear why it has been rejected anyway, but
Having heard the learned advocate appeal for the respective party and upon considering the materials of the court placed before us, we are of the view that there is no scope of passing any meeting order. And that should be. The petitioner is directed to file requisite number of informal paper proof incorporating all the pleadings and the document placed and used before the learned tribunal within a period of
Within 6 weeks.
as well as
With all pleadings, Lordship. Paper book,
Yes, that has been
yes,
sent.
paper book.
Instructions from date with copies to learn it advocate appealing for the result.
You have for all the respondents.
Railway, yes.
Copy to the Salam, learned
Eastern Railway,
advocate.
yes.
Salam learn it advocate appealing for the response. ঠিক আছে?
Lordship, the registrar has also said, the Central Administrative Tribunal has also been made a party.
No,
So it should be up to 4, not all, Lordship.
be upon the Salam
Railway
learned
Railway, I'm for the railway authorities, Lordship, not for them. 5 is the registrar.
Hearing for the
respondent numbers.
appeal for the one,
And Lordship,
four.
Lordship 1 to 3, because this Zonal Railway Training Institute, Lordship, I don't think it's an existent institute. I was just gleaning through the papers.
Very good.
1,
We-
2,
that
1,
you-
2,
that- No, otherwise we will dispense with service. We will record your
Lordship,
appearance.
Lordship.
Upon Miss Alam learned advocate appearing for the respondent numbers 1
to 3.
1 to 4.
1 to 3 বলছেন
Now 4 is there. Eastern Railway Institute.
Whether that institute
Yes,
exists or not is
Yes.
also to be,
আচ্ছা 1 to 4.
whether it exists or not
That
is
you- that
also
you
understood.
mentioned.
I shall mention them.
ঠিক আছে? হ্যাঁ লিবার্টি টু মেনশন after filing of the paper.
It will appear after 6 weeks
No,
Liberty to mention.
as well as.
Liberty to mention for enlistment and hearing.
after that year.
Well, up to 15, up to 15.
Same
serial
order
number,
up to
same,
15, Lordship.
all are
Same.
similar,
ওপরে evidence of
Yes.
service.
up to 15,
7 to 15, all
7 to 15.
Same.
Each every service. All,
15. হ্যাঁ,
I'm
7 to 15.
7 to 15, my lord.
7 to 15, Lordship.
Yes. Next.
Lordship, I am appearing for the petitioners in this matter. Lordship, I have challenged the order passed by the learned Central Administrative Tribunal.
Who is your other side? You're appearing?
No, I am the advocate on record.
Uh-huh.
He is my advocate on record.
Oh, he is your advocate. Your service complete.
Yes,
Yes.
yes.
Lordship, service complete.
জয়ন্ত পাল্টা তো না হ্যাঁ জয়ন্ত পাল্টা রিয়েল এদের মামলাটা না মানে লার্নেট ASD is appearing through virtually ballot.
Yes, tell us. Yes.
Lordship, I have challenged on several grounds. That is the
What you have challenged?
Lordship, the railway, they are saying that the railway protection force is not the under the purview of the railway employees. But according to the Railway Act 1989, Section 2, subsection 34 says the railway servant means any person employed
Now,
by the
what has happened to these 11 vacancies? They have been filled up.
Lordship, some filled up with the RPF personnel who passed 5 posts, they have segregated.
Those 5 posts have been filled up.
No,
Yes,
has not
Mr.
been filled
Ghosh.
up. But new recruitment
Well,
process has been started.
Lanet ASD is appearing, just now he also told me he is appearing through virtually, my lord.
You have not taken any instruction.
Yes, my lord, actually, my lord, in this matter, I am led by him, my lord. And he just now, my lord,
So you may be led by him, but you don't know. Have
Yes.
you got the instruction?
yes,
What
yes.
about the vacancies?
My lord, regarding that earlier,
Vacancies we are asking, have you filled it up or not?
no, my lord, that proceedings has not yet been completed, selection process.
Lordship, in
What
which,
interim order you want?
Lordship, I want let the 5 posts be vacant till the disposal of this application.
You take instruction and come back. What is the status of the vacancies?
In total, my lord, 7 vacancies is there, my lord, in
11 vacancies were.
Out
my
of
lord,
11 vacancies, 5 vacancies has been filled up by order of the Honorable Court.
Then in the tribunal, did you enjoy any interim order?
No.
Then what interim order you are wanting?
against my lord,
Only 5 posts, only the RPF post which they have stalled, it should be vacant till the
No.
disposal of this
Then
application.
why didn't you get that order before the tribunal? Did you
They,
believe-
they directly they cancelled our application.
No, reply rejoinder was not filed.
Yes. It was,
Then you did not pray for any interim order.
but total, my lord, 11 posts, the 7 post was, my lord, for departmental quota, man.
And Lordship, kindly come to page 75, upon which circular they have cancelled our application. The process was start in the year 2015. Petitioners successful in the Viva written test, and they were prepared for called for Viva test, and in the meantime, this circular has come.
My lord, written examination is already held, my lord, on 27 January, my lord.
Hmm? Hey, please bring a list of dates and is it possible for us to ascertain?
Also, then give me 3 days time. I will supply the list of dates and
Next Thursday.
first.
Yes. You will have it. Yes.
That's 79 AP.
There was a Passover. Sorry. Where is that Passover matter? What number? Where is here come?
Matter is going on, my lord, on 238, my lord, item number 1.
What is the matter about?
My
What
lord,
did you say?
That is an interim order. My lord, I filed an application before the Central Administrative Tribunal, my lord, to allow me, my lord, to submit my application. My lord, the tribunal filed virtue of interim order. I was allowed to, my lord, submit the application. Now the reply rejoinder is everything ready. My lord, on Monday, my lord, the tribunal has fixed the matter for final hearing of the original application.
What is your case then?
Then, my lord, I am praying for not today, my lord.
No, not today won't.
Then, my lord, pass over, my lord. His matter is going. Matter
Who is your senior?
Mr. DN Rai, my lord. I'm not aware in this matter, my lord.
Ask him to appear at 2 p.m.
Yes, my lord.
or we pass order.
Yes, my lord.
Yes. Come at 2 p.m. Yes, call. Next Thursday. Yes, next.
That's 79 AP. And but this is a case where, my lord, I have completed my service of, my lord, 19 years, 7 months. Now, my lord, I have not been given full pension. My lord, I approached the tribunal once, but the tribunal directed the respondents, my lord, to consider.
Got your benefit. What
No.
proportionate pension has
But
been
proportionate pension, not the full pension. Your lordship has decided the issue. I'm before your lordship. But in single bench, my lord has decided many of the issues.
That is in respect of aided institutions where there was no provision towards proportionate disbursement of pension.
Absolutely. And furthermore, your lordship has waived that 6 months.
That was Mr. Bhattacharya in case there was no provision for grant of proportionate pension as per the service render. Here it is a shortfall. However, you have been calculated, pension has been calculated on the basis of the period you rendered as such.
Absolutely. But
So there is no wrong. Have you challenged the notification of 25th February 2009? That notification did you challenge?
Your lordship, kindly have a look
to
to the
proportionate pension was disbursed.
Yes, page 36.
Page 36.
6.
Yeah, কি হবে? No inching order. No scope of inching order.
I tell your lordship. May I?
আরে কোনো inching order তো নেই. File your paper books upon
Paper
hearing.
book.
Yes.
The person is getting 9.
You have annexed all the documents.
Entire document of
Mr. Mukherjee, do you want to use any opposition to
Yes,
further
They have filed a report that is also annexed.
any factual aspect you want to use?
But so far as dealing with the 25th February 1999, I shall have to file an appeal.
Which one?
25th February, page 36.
Page 36, 25th February 2009. Notification. Just now my lord has mentioned.
Page 36.
6. Well, whether the condonation can be done by the government or not. The department has said that we have condoned, but in case of 6 months, we have condoned it. But it is the discretion of the government that we will not condone. In case of 20 years. Rule 36 is for condonation.
All right, let him come with a name.
Hard
Mr. Bhattacharya and dead.
Affidavit will, your lordship knows, affidavit matters it is such, when the
If he wants to use an opposition,
file a short report so that it can be treated as a motion and
making it returnable. Let him file the opposition.
Very good. Otherwise, in case of hearing matters, your lordship knows, when we mention hearing matters.
Hard Mr. Bhattacharya Evidence of Service. Appearing for the petitioner, Mr. Mukherjee, learned DGP. Appearing for the respondents.
Except respondent number 5.
They appearing for the, who is 5?
5 is AG Bengal.
1 to 5.
1 to 4 and 6.
1 to 4 and 6 place for leave to file an affidavit in opposition. Stop. Let such affidavit in opposition be filed within 2 weeks.
I will kindly make it 3 weeks.
3 weeks. Reply thereto if any be filed within a week thereafter. List the matter for final hearing. 4 weeks hence. Yes, next.
At the moment the file is gone down to the department, but it is very difficult to get it listed.
Yes, Mr. Next.
18 million beg to appear for the
Item number
18, lordship. The state is the petitioner, Millard. I beg to appear for the petitioner, lordship. The issue is very.
I appear on behalf of the respondent number 1 applicant.
The issue is very short and simple, lordship. A disciplinary proceeding was initiated against respondent number 1 in the year 2015. There was delay in concluding the disciplinary proceeding. Respondent 1, Millard, approached the learned tribunal. The learned tribunal was pleased to direct that yes, it's quite late. You started the disciplinary proceeding in the year 2015. So you'll have to complete it within 6 months from date of communication of this order. The order was passed, Millard, on 26th February 2021. That is, Millard, at page 54. Millard, disciplinary authority could not complete within 6 months from date of communication. Millard, the date of communication of this order, 26th February 2021, was on Millard 3rd March 2021. 10th March 2021 was the date of communication. So 6 months was due to complete, my lord, was on 10th September 2021. But, my lord, the disciplinary proceeding final order could be made on 11th May 2022.
That they challenged.
My lord, the lady, my lord, again, my lord,
Challenged that one.
appears before the learned tribunal saying that since your lordship on earlier occasion was pleased to direct, a peremptory direction was given to complete the proceeding in 6 months. If not done, the disciplinary proceeding shall stand vitiated. This was the sentence used in that particular order of 2021. So they have failed to comply with that 6 months time frame. So although final order has been passed, but beyond that, hence the disciplinary proceeding stands vitiated. So, my lord, what the learned tribunal does, my lord, by the impugned judgment is that yes, since you have failed to comply with the time frame of 6 months, so entire proceeding also stands vitiated. I quash everything.
What was the charge?
Charges, my lord, she had, my lord, given some undervaluation of a property. She was
She has
working in the capacity.
She has retired or is in service?
She has not yet. She has not yet retired. Punishment was reduction in pay. Reduction.
Did you approach the tribunal for extension of the time?
No, because it is not, my lord, necessary, as because, my lord, Honorable Learned Tribunal has failed to take note of the Supreme Court judgment with regard to pandemic situation. When, my lord, Honorable Supreme Court was pleased to, my lord, extend lordship knows the time frame and the very, my lord, case is very much governed by, my lord, the Supreme Court Honorable Supreme Court judgment,
So
which has also been subsequently held by the Honorable Coordinate Bench of our court in a self-same issue regarding completion of this disciplinary proceeding.
But you did not approach. You could have told the tribunal pandemic prevailing, extend the time. Tribunal would have happily extended.
No, that was, my lord, that was not the case, lordship. That was
26 February 21 was the order. Final order was passed on 11th May 2022. Pandemic was over by that time.
no, lordship. Kindly, may I respectfully invite your lordship, my lord, to the relevant
How
part.
do you cross the hurdle of not having approached the tribunal?
Not having approached the tribunal because in the meantime, my lord, we have already passed the final order of punishment.
Still, when there is a tribunal, you have not you did not assail the initial order, which says that after 6 months, if you do, it stands vitiated.
As because, my lord, because of the extension given by the Honorable Supreme Court, my lord, kindly cease, my lord, for once, my lord, may I respectfully invite your lordship. Automatic. We are automatic covered by that judgment. So there was no need, my lord, for approaching in my harmful, my lord, respectful submission, my lord. Kindly, my lord, may I respectfully, my lord, invite your lordship, my lord, to the, my lord's, my lord, Honorable Supreme Court judgment.
You have any?
Lordship, this, my lord, has been covered by a coordinate bench judgment of our Honorable Court, my lord. Self-same issue where, my lord, the disciplinary proceeding, my lord, could not be
It will come later. First, the Supreme Court.
No, it is the entire Supreme Court judgment is covered in this particular, set out in this particular judgment, lord. May I, my lord, respectfully, my lord, hand over this copy of the judgment, lordship. My lord, may I, my lord, respectfully, my lord, place this judgment, my lord, kindly seize the issue, my lord, involved.
Judgment will come later. Tell us the facts first. You show us the first
Fact in this particular matter also is akin, my lord, to the, my lord, case which we are before your lordship. In this matter also, my lord, it is the same fact. May I, my lord, respectfully?
Show us the order.
Yes, lordship. No, I have handed over this judgment.
Why the judgment? Proposition of law you place that Supreme Court has said that even in departmental proceeding, time can automatically be extended.
Lordship, my lord, that
was the Supreme Court judgment. We are not concerned with the coordinate bench judgment.
Lordship, Supreme Court, my lord, Honorable coordinate bench judgment, my lord, has set out the entire portion, relevant portion of the Supreme Court judgment.
Why didn't you bring that judgment? Where is that portion quoted?
My lord, internal,
was the portion quoted.
internal page 5, lordship. Right. Internal page 5, my lord, paragraph 12. My lord, pandemic, may I read out, lordship?
Yes.
Pandemic condition prevailing in the country at that material point of time. Honorable Supreme Court lodged a suo motu writ petition number so and so with regard to limitation in respect of proceedings before courts tribunals. From time to time, various orders were passed. One of such orders is dated January 10, 2022, wherein the Honorable Supreme Court issued the following directions. Taking into consideration the arguments advanced by learned counsel and the impact of the surge of the virus on public health and adversities faced by litigants in the prevailing conditions, we deem it appropriate to dispose of the MA number 21 of 22 with the following directions. 1. The order dated 23rd March 2022.
We are reading internal page 5.
Lordships. Internal page 5, my lord,
Page 6 is missing.
paragraph 12.
কিভাবে place করে বুঝতে পারি না।
This is a copy of your no mark. It's okay. 600.
I'm sorry, my
Sorry,
lord.
though marked.
Lordship, may I read out, lordship? It's there, lordship. 5 and 6 is there, lordship. May.
You want back your copy?
No.
No. The lordship may read out. So, my lord, this is the paragraph 5 set out, my lord. And kindly see, my lord, internal page 6. The order dated 23rd March 2020 is restored, and in continuation of the subsequent orders dated 8 March so and so, it is directed that the period from 15th March 2020 till 20th February 2022 shall stand excluded for the purpose of limitation as may be prescribed under any general or special laws in
As
the
may be prescribed.
lordship,
As may be
lordship
prescribed.
of all judicial or quasi-judicial proceedings.
No, not that. As may be prescribed where?
As may be prescribed under any
Under-
general or special laws.
Under any general or special laws, not as may be directed by the court.
No, lordship, but in this
Tribunal.
matter, lordship, kindly, may I just place our lordship? This judgment squarely covers my case, lordship. Because in this,
Are we clear to you?
no, it is clear, my lord, as prescribed by any general or special law means
So,
where limitation is being set out in a particular special or general laws.
legislature,
Legislature,
not in judicial order.
not the direction of any, yes, lord, judicial order.
Yes.
But, my lord, in this particular judgment, my lord, lordship, my lord, so, my lord, may I read out, lordship? My lord, lordship, special laws, I am at the same point. In respect of all judicial or quasi-judicial proceedings. Clause 2. Consequently, the balance period of limitation remaining as on 3rd October 2021, if any, shall become available with effect from 1st March 2022. Clause 3. In cases where the limitation would have expired during the period between 15 March 2020 till 28 February 2022, notwithstanding the actual balance period of limitation remaining, all persons shall have a limitation period of 90 days from 1st March 2022 in the event the actual balance period of limitation remaining with effect from 1st March 2022 is greater than 90 days, then longer period shall apply. My lord, my respectful summation, my lord, I am governed, my lord, by this particular clause, my lord, of the Honorable Supreme Court judgment, lordship. Because, my lord,
Where is the limitation prescribed for concluding a proceeding?
as because, my lord, may I respectfully submit, my lord, in this particular judgment, my lord, this coordinate bench judgment of this Honorable Court has been held, my lord, is on a subject of disciplinary proceeding. Time was, my lord, granted by the learned tribunal for completing the disciplinary proceeding within a particular time frame. The coordinate bench, my lord, has been pleased to hold that yes, disciplinary proceeding is a quasi-judicial proceeding. Hence, this particular exemption, which has, my lord, been given, my lord, by the Honorable Supreme Court, will govern the disciplinary proceeding also, my lord. Hence, my lord, if any particular disciplinary proceeding, despite the time frame, had been given by any learned tribunal, if could not be completed, it will
Any time frame provided in respect of disciplinary proceedings to be concluded within a specified time. There is no time frame provided. Under your disciplinary regulations and laws, There is no time prescribed that you, once you include, start a commence a disciplinary proceeding, you have to complete it within 6 months. Had there been a specified period, you could have argued that that period, as it is in pertaining to a quasi-judicial proceeding in terms of the statutory law, you please allow me this extension.
Lordship, here, my lord, we are not, my lord, on the point of the period of limitation within which, my lord, disciplinary proceeding is to be completed. Here, my lord, the issue in the lease is that there was a direction by the learned
I think you have not understood what I am saying. Maybe I have not made my case clear. Suppose, Mr. in a disciplinary proceeding, there is no period of limitation.
Lordship.
So the litigant approaches the judicial forum that you fix a time. Court fixes a time.
Lordship.
You admittedly do not approach the court that extend the time frame. This
Lordship.
is a new argument you are making. This argument ought to have been there for extension of the time.
So my respectful submission, my lord, my respectful reply to you, Mr. Lordship's query, my lord, is because this, my lord, subject is squarely covered by this judgment, Lordship. This Hon'ble coordinate bench.
We are not clear to you, or
No, my lord, my lord, there is no time.
in view of COVID pandemic, considering the difficulty faced by the litigant of across the country, Honorable Supreme Court suo motu took cognizance of the situation and extend the limitation, period of limitation. Period of limitation fixed by the legislature in the any general or special law, but not the period fixed by any court, tribunal, or any judicial institution. Am I clear?
Lordship, my lord, it is also very much clear to me also. But Lordship, kindly.
Because it was not intention of the court that to encroach upon the domain of the court. No. The Honorable Court was done. They have encroached the law of limitation and stated that law from 15th to such and such 18th February 2022 are excluded.
Lordship.
But they have not stated that the period fixed by the court is also extended.
But, my lord, may I respectfully submit, by this judgment of the coordinate bench, my lord, it is specifically pat on the point, my lord, with the case, my lord, which I am before your lordships.
Can you show us the 2021 SCC online, Nilima Srivastava versus State, which has been posted by the bench? This is 2021, no? This quotation.
No, may I, lordship, my lord, may I respectfully, my lord,
see the judgment, Mr. This judgment of 2021 passed on 10. Do you have that?
And that was considered. No, I am not with. It is not with me, my lord. That was considered also, my lord, by this judgment.
Please show us the judgment. What are the facts there? Let us go through it.
Sure. George, kindly, my lord, adjourn, my lord, for the day so that I can come with that judgment, lordship. But, my lord, fact in issue, my lord, before your lordship, my lord, is also the fact, my lord, before, my lord, the honorable coordinate bench also.
We have a right to defer, Mr. Moore.
Certainly, lordship. Certainly, I am certainly, lordship.
Seen a judgment of Supreme Court before.
No, lordship, lordship.
So don't say that.
No,
we
no.
have a right to defer with the judgment.
Lordship.
You please show us, come tomorrow with the judgment.
Lordship.
If individual service filed by the any other respondent who is necessary.
No, that is the only, my lord.
The advocate appeared before the petitioners. And he said, this is the matter for further consideration under the same heading.
My lordship.
Any other respondent not there?
No, there is a pro forma, my lord. PSC is the pro forma. So PSC is.
Evidence service filed by the petitioner has been kept on record in course of hearing. Mr. Learned advocate petitioner prays for an accommodation to produce the judgment of the Honorable Apex. This is the matter for further consideration on such. Mr. Trivedi, learned advocate, enters appearance on behalf of the respondent numbers.
1.
Chaturvedi. Chaturvedi. Yes, yes. Chaturvedi. We are not remember. We remember the full name, not the half.
Specific. 1 to 4.
Please bring that judgment issue.
Item 19, my lord, I appear for the petition. This is the affidavit.
5 minutes. Can I appear on? Myself. AGP नहीं लिखना हमको पसंद नहीं है. Only solution. I don't like these things. Okay.
My lord, in this matter, my lord, I have challenged an order passed by the learned tribunal on 17th of January 2024. Now, my lord, if your lordship sees the order, in this order, it says, my lord, such and such learned council submits as per the direction of this tribunal, the respondent's authority have taken concrete steps to conclude the disciplinary proceeding. On 13/12/2023, the applicant appeared and was heard, and subsequent steps are required to be followed for concluding the proceeding. Is been taken, and therefore, such and such prays for further time to conclude this. Such and such learned counsel appearing for the applicant, however, objects to the extension of further time and submits there is no justification for such liberty since the application has been suffering without any reasons. Now, my lord, if your lordship takes up the just preceding order of 17th of January, my lord, that is page, my lord, 60. My lord, before I go to the judgments, my lord, the orders, my lord, initially I was proceeded, my lord. A punishment order was issued. I challenged the punishment order, the proceeding itself. The learned tribunal said proceeding is quashed, the orders were quashed with a further direction to the authorities to conclude the proceeding within 4 months' time. After, there is no vitiation clause, my lord. Simply directions were there. My lord, after more than 6 months or 8 months have passed, I again approached the tribunal saying that, see, the tribunal has initially granted 4 months' time. Now that 4 months is over, your lordship, the tribunal should take the cause. Now, my lord, on the very first day, direction was issued. The respondents appeared. They say, my lord, they require time to take instruction. Now, that is an order dated. My lord, if your lordship takes up the order, it is
14/7.
an order dated, my lord.
Who is for the applicant?
Yes, I am appearing on behalf of respondent number 1 to 4.
My lord, page 61. Now,
Who are the applicant before the
tribunal, my lord. Now, your lordship takes up page 61. My lord, this is the tribunal's own order. In my respectful submission, my lord, if this order is to be flouted, my lord, then the entire thing will be taken into toss. Your lordship, kindly have a look at the order, at the concluding part of the order, page 60.
14 July 23.
No, my lord, 15th of September, page 66.
15/9/2023, your lordships.
60, my lord.
15th of
September. 15 September, my lord, page 60. 60.
60.
60. Lordship has got it, my lord.
This was 15th, this was the first order.
This is the second order, my lord. First order, they took instruction.
Where is first order?
Yes, my lord. The first order is that page, my lord. Next page, 61.
So what is the 7, okay, 61?
Well, this is the first order passed.
Consent, take instruction.
The next order, your lordship will find 15.9.
Yes.
Well, the concluding part, your lordship takes up the last paragraph. Having heard the submission of the learned counsel and having come to the conclusion that the disciplinary proceeding has not been completed despite lapse of 1 year, respondent number 4, the district registrar Purva Midnapur and the disciplinary authority is hereby directed to comply with the order of the tribunal passed on 9/8/9/2022 and conclude that disciplinary proceeding within the next 2 months positively, failing which the entire disciplinary proceeding will stand vitiated. Now, my lord, this order passed by the same person. Now your lordship sees the impugned order. Without any writ petition being moved before your lordship, without any extension of time, without any modification, without any review application, the same my lord, member passed the impugned order, which is, my lord, dated 17th of January, extending time. And my lord, my humble full submission, my lord, as today also your lordship in many cases have said, it has reached its finality, the doctrine of finality. But I am also covered by the judgment of the Supreme Court, which says it is binding between the parties, unless it has been assailed before a higher forum, or, my lord, any application is taken out there too.
This 13th December order? Referred to in the order include on 13 December the applicant appeared and was heard.
My lord, my lord, the first time, my lord, after the initial order was passed by the learned tribunal, I was asked to appear before the authority.
Where is that order to complete within, this is the first order. OA 395, page 60.
Page 60 is the first order, a second order in the second round of litigation, my lord. But there are 2 rounds of first.
Where is the first round of litigation order?
My lord, page 49.
8/9/2022.
My lord, this is order dated 8/9/2022. My lord, the operative part starts from page 53.
बस just हमको ये बता दीजिए ठीक है got it okay September
Then why it has been kept for orders on 17 January 20?
My lord, as because the earlier order of, my lord, 15th of September, it says, if it is not concluded within 2 months' time, it will be vitiated. It was kept on 17th so that if it has been concluded, my lord, whatever order is there is there. If it is not been concluded, my lord, supposedly the tribunal ought to have, my lord, in my humble submission, my lord, subject to lordship kind consideration, the tribunal ought to have vitiated the proceeding in terms of its own order. But, my lord, on the contrary, my lord, neither.
So what happened after this 15 September?
My 15 September order, my lord, I was called in by the Vigilance Commission to attend the hearing. My lord, I attended there.
When did you attend?
My lord, of 5th of December.
yesterday also you have appeared are you
Well, 13th of December. 13th of December, I have asked to appear. I appeared.
13th of December. 13th of this order was 15 September. Complete within
2 months.
2 months. And you were called after 3 months.
Yes, my lord. I was called, my lord. Still, my lord, I obeyed the order, my lord. I never say anything to that, my lord. I attended. Now, my lord.
What is that notice? Calling you for 13 December.
My lord, your lordship, although the notice they have produced, if your lordship takes up the impugned order, your lordship will find there is a reflection in the order.
So how you are agreed by this order?
My lord, your lordship will find page 60.
Admittedly, there has been a delay on their part.
Yes, my lord. So
matter has been kept for orders.
No, my lord, on 17th, my lord, the tribunal without any extension petition, my lord, on 15th, the tribunal passed the order. On 17/1, my lord, the tribunal without any extension application, without any modification or review or a writ petition moved before this honorable court. The tribunal suo motu, my lord, extended. That cannot be done, my lord. Your lordship kindly considers is my humble
Where
submission.
is that? 17 January 2024?
That is the impugned order, my lord.
Yes, now issue has not been decided as yet.
No, my lord, what the tribunal said,
Pending,
my lord, your lordship, the tribunal says, Mr. Such and such submit the adverse direction of the tribunal. Respondent authority has taken concrete step to conclude the proceeding. On 13/12/2023, the applicant appeared and was heard. Subsequent steps are required to be followed for concluding the departmental proceeding is being taken, and therefore, Mr. Such and such prays for further time to conclude. Now, my lord, can the tribunal, my lord, pass an order receiving its own order? Page 60 clearly says, my lord, that the same
Extension was not granted.
No, my lord.
Extension was not granted by 17 January 2024.
My lord, your lordship will find.
Yes,
Uh,
your submission was recorded matter fixed for orders.
My lord, can the tribunal, my lord, subject lordship kind consideration? I may be wholly wrong.
Tribunal says your contention is when the tribunal has observed that if 2 months you do not complete, proceeding will stand vitiated. Having observed that, how can the tribunal again fix it on 17th of April?
Yes, my lord.
When admittedly the proceeding has extended the period year one.
Deeply blessed, my lord.
But that issue has not been decided.
My lord, your lordship kindly says that the moment.
17 January 24 shows that it was decided.
No, my lord, it was in that sense, my lord, on 17th of January order, the tribunal fixed the matter for orders. It could have done it on 17th January itself as because 2 months time is over.
That is a separate issue altogether. There is no line that your apprehension is justified.
No, my lord, as because I appeared there, my lord, I was the petitioner before the tribunal.
You approach a judicial proceeding and you start anticipating, then it becomes difficult. No?
That's true, my lord. But subject kind constitution, my
Today
lord.
I may be in your favor, tomorrow my mind might change.
That is
But if there is reflection of my mind, as you have correctly said, that if there is a prima facie reflection of mind, you cannot act contrary to that.
That's true, my lord.
So tribunal has said, months, initial order, 2 months you have to complete, otherwise it is vitiated. I am fixing it on that. They appeared and said that we have not completed. You said that no further extension, both the submissions recorded, and for orders it has been fixed on that. Now, if the tribunal says that no, all right, it is I am extending, I am doing everything, then you may be able. That's what I think.
No, subsequent step are required, is being taken. Your main concern is that subsequent step is being taken. You are thinking that thereby the tribunal has extended time.
Exact, the learned advocate appealing for the.
That is the submission of the advocate as recorded.
Yes, ma'am. That is on submission, ma'am. There is a submission that.
No finding on it.
But my lord, my apprehension is this, my lord, as the tribunal on that day, I'm subject to, I understand what your lordship has said, my lord. I will try to convince your lordship to the extent possible. My lord, in my humble submission is this, my lord, the 15/9 order.
Wait for 23rd.
My lord, may I make a humble submission, my lord? Let the writ petition be pending, my lord. Let the writ is a very poor man, my lord. He's a UD, he's not getting the salary or pension. A meager pension he's receiving, my lord. Again, if you have to come before this honorable court, my lord, it will be a huge burden for him, my lord. Your lordship kindly consider this aspect also.
But if we keep it pending, if the tribunal passes a fresh order, that has to be challenged by.
My lord, with your lordship leave, I can come with a supplementary if such order is there. But in the tribunal application, my lord, page 36, my lord, I have made a categorical prayer.
জিজ্ঞেস করে তাহলে ঠিক আছে
Withdraw with liberty. Because if we return a finding, it goes against.
I understand, my lord. I understand, my lord. Absolutely understand.
Choice is here. If you want to, you should. Please think over it.
Dates के बारे में बोले ना छोटी
My lord,
Now, if the tribunal extends the time,
yes, my lord.
then you ought to come before this court.
Fresh cause of action.
Fresh cause of action. Then if in the meantime the department pass final order, then again you have to come approach.
Yes, my lord. My lord, only thing, my lord, my lord, may make a humble submission, subject to lordship leave. Can this be on this Friday, my lord? This matter? As, no, my lord, the original advocate on record, my lord, let him be there, my lord. At least I will take instruction from him. Let it be on Friday. My lord, only 3 days, my lord. On that day, I will withdraw, my lord. Let he be present, my lord.
Moreover,
My lord, it's lordship.
Moreover, your lordships, may I submit that yesterday a date of hearing was fixed on the 5th of February and he had participated on instructions. I'm submitting this. And moreover, on the last occasion, that is on the 13th of December 2023, he was supposed to file certain and he had participated and sought for time to file certain documents which were required for adjudication of this matter before the authority. So it is not this that we are sitting tight. We are looking into the matter. We are intimating him. He is participating.
Then you are treating the tribunal's order to be an odious one. I don't obey by that.
No, your
Just
lordship.
come and taken the documents, I will argue. Huh? Then what is the use of existence of judicial forum? Huh? You governmental authorities, you can think that I can act contrary to the order. Let them do what they want. Huh? This is your attitude. Starting from 1960, Supreme Court has said that if you are the government, you must be extra cautious about your work. Huh? And you leave these persons to the contempt of the tribunal, matter will be heard after 10 years. God knows whether person will be alive or not. And you say he appeared, my lord, he taken the documents, barred by estoppel, etc. Huge argument. Right. Evidence of service filed by the petitioner be kept on record. The learned advocate enters appearance on behalf of the respondent numbers
1 to 4.
And we only 5. Only
1
5.
to 4 and this
Principal accounts general.
for 5.
Yes, principal accounts general.
All the respondents are appearing. Evidence of service filed by the petitioner be kept on record in course of hearing.
इसे पूछो कब तक conclude कर रहे हैं?
Please have an accommodation to every necessary. Please the matter under the heading to be mentioned in the daily supplementary list of this court on Friday. Huh?
Friday or Monday?
Friday.
Friday to be mentioned. If the withdrawal is finished, then otherwise we will hear.
Grateful, your lordships.
To be mentioned with you.
Lord, I appeal for the petitioner, my lord. Lord, this matter, my lord, the petitioner is challenging on transfer order. My lord, the petitioner before lordship.
Item number.
The petitioner before lordship is a doctor, my lord. She has been transferred. My lord, she is a single mother, my lord, and a caregiver of a my lord, mentally retired brother, my lord, who is 70% mentally retired. My lord, that is on record. My lord, I am being transferred from Paschim Bardhaman to my lord Rampur Hat Hospital as a deputy CMO. So my contention is this before the learned tribunal was this, my lord. This is, my lord, against the circular which has been annexed in this writ petition is also there. My lord, it says that in case of somebody who is having some
The court has not disposed of.
No.
Well, not disposed of, but your lordship will find, the court has came to a finding that circular is there. But if your lordship sees the reasoned order, this is one of the most peculiar reasoned order your lordship can ever look into. But the reasoned order in terms of the
What is the ground of challenging this order? The matter has been admitted, matter fixed on 13th June.
in terms of the if your lordship sees the reasoned order was under challenge.
Any return finding has been returned?
No finding is there, my lord. But
why you are in a hurry?
My lord, your lordship, as because my lord, my case of transfer is this, my lord. There is a circular of the government which says, in case of somebody who is mentally retarded.
When did you join the post?
My lord, I joined the post. After the transfer order, my lord, I moved an original application. My lord, before the original application could be heard, I joined. My lord, these are not in dispute. So, my lord, the original application initially was disposed of by directing the authorities to consider my representation and pass a speaking reasoned order. Now, my lord, they have passed the order. The lordship will find the order at page.
No, why we are going into the order, sir? Tribunal has recorded that reasoned order has been passed together with an observation that we are looking into it as and when vacancy arises, we will place.
Yes,
This
ma'am.
was the assurance given. At the same time, your contention was also recorded that if you are the legal guardian of a handicapped person, in that case, you deserve some precedence.
So that is circular is also there. My lord.
For that reason, the tribunal has asked them, all right, we have heard you, I'm admitting the petition, come back on it. On that day, if they say that we are not, you will place that circular again.
Right.
Why
Yes,
you are coming to us?
It's because my lord, in my humble submission, as the circular was there, tribunal quoted the circular.
So has the circular been decided, sir? The tribunal is in session of the matter.
But my lord, as long this circular is there, my lord,
Scope of imprimatur act. When I both person the imprimatur banging bole apply. There is no scope. Okay. Oh, it is.
Withdraw it.
Oh, join.
my lord, only thing may I subject lordship kindly, my lord. But your lordship direct the tribunal to heard the matter expeditiously as possible, as because transfer is there, my lord. I will be on in the soup.
You have not made out any.
No, I have not made that prayer, but your lordship can anytime mold the prayer, my lord, subject lordship, with the plenary powers of the court, my lord, your lordship can. But at least if the matter is heard on that day, my lord, after
Unnecessary apprehension. You are saying that
So, shall we pass our order?
I'm withdrawing with the lordship kindly direct the tribunal if the lordship allows, my lord.
No.
Direct the tribunal to hear it out expeditiously. This much I may pray, nothing more.
No, clear on your part also in your petition.
That's but
Yes, challenge
Read
the order
court
of the
can,
court.
the read court can, my lord. The read court can mold the prayers, my lord. The plenary jurisdiction, the read court is having, my lord. Your lordship can.
you have challenged that order. Withdraw it without taking a finding on it.
That will be better. Acha,
Diploma.
all the PR service, PR service, we get with the record. And on the PR of the learned advocate appearing for the petitioner. Petition is dismissed.
We have dismissed as withdrawn. Yes, next.
Item number 51.
21, who's there?
আমার উপর কিছু বলবে না আমার কিচ্ছু বলেনি
অর্ডারটা কন্ট্রোল করে আপনি করেন তখন আপনি
বেশি এখন বাজেট নিয়ে করে এবার
বলে দিন যে আমাকে তুমি একটু ইয়ে করো সেটা বলে না
একই কথা
Your Honor, in this matter, an order was passed on 12th of December 2023.
Mr. Mukherjee, you're really kind. You have accepted, you pay 3 lakhs.
no what we have not accepted
You are really kind-hearted. Pay it, pay it.
But if I pay this gentleman, then the third gate will be open because other departments.
We will fortify you that it will never open flood. Our coordinate bench has expressed an opinion. Finance Secretary has been requested that in view thereof court considers that matter will end it. This matter.
But kindly send it the matter for consideration by the.
ও আর করবে না। এই কথা বলছি। আর হয় নাকি?
No. He shall have to prepare the budget.
Bring the check, whatever safeguard you want, tell us, we will inform.
Kindly see the order passed by the learned single judge.
We are not going into that. Coordinate bench has requested you. Your only problem is that this might create a precedent. No, why should it? We have.
No, according to our information, this university has employed a large number of employees without the permission from the government. And now, because after they have retired, they are asking for the financial benefit. And other organizations, undertakings, made the same thing without the approval of the state government. Approach it in the court.
No, the court has said that persons similarly situated with him have
Yes,
been
regularized. And Miller, that document has also been annexed.
2024. That is after, because I am not good in mathematics. You must be.
15 years, 16 years going on.
16 years going on. If he had been regularized, how much he would have paid?
But no regular.
Regularization 2008, he was attended age of 57.
That is why regularization.
The main problem. And
So what about you for the university? So you did not engage him since he was 57. Why?
Because
when similarly situated have been done.
Whoever the regularized, they have joined at the age of before age of 35.
Miller, the particular regularization, Miller, kindly see page 80, 81 of the particular stay application. Page 80 and 81. Miller, kindly see addendum 2, proposal of regularization of service, Monojit Kumar Chatterjee, Ranjit Raj Chaudhary, then this Devtaru De Surojit Bishoy.
was placed in the meeting, the principal secretary opined that as per the existing geo, they would be regularized. All persons have been regularized excepting me. And this decision was taken on 27/10/2008.
No, why they has not approached this court in 2006? This, if there is a cause of action.
Mr. Mukherjee, there is no antagonistic controversy.
Yeah.
Court has said that when the ethics court says that on these facts, Mr. Mukherjee, you can consider it. Court was also said, rightly said, that we are adjourning it so that you can come with the relevant communication as regards. Court has not gone into controversy or any acrimonious controversy.
Yes, your lordship is correct.
When a judicial order is passed, then the question of compliance or non-compliance. In the facts and circumstances, court has requested a senior officer of the state to consider this and come. So ultimately, matter can be ultimately heard at any time. Court will hear, court
Your
will
lordship is perfectly correct.
But when you are there and when this is here, when you are a senior officer of this state.
Well, kindly adjourn for the 2 weeks so that something development can be taken place before your lordship.
Yes, I have not.
That we will keep, but Mr. Mukherjee, we request you to look
Yes.
into it. Then, or if you ultimately find it is reasonable, please check on that.
No, we cannot pay a check. When a fund will go to the
transfer.
university.
Your bank account details.
I will be.
No, but until unless the finance department agrees,
We are not.
the payment will be made by the university. Because we have already allotted the fund on the basis of the budget allocation.
3 lakhs, I don't think this budget will be having.
No. Whatever the expenditure of the university, we have paid to the university. For payment of salary to the teaching or non-teaching staff and including vice chancellor and other staff, control of exemption, registers.
Mr. Mukherjee, Mr. Bhattacharya, senior advocate for the appellant. Mr. Mukherjee, learned additional government leader. Please, for an accommodation to date, we avail necessary instruction. In view thereof, release the matter under the same heading. Tell us, Mr. Mukherjee, when can
After 2 weeks,
tell us the date we will. The supplementary list of this.
আপনি সরস্বতী পুজোর পরও এক সপ্তাহ নিয়ে নিন।
This is the matter under the same heading in the daily supplementary list of this court on
21st.
21st.
আমাকে দিয়ে দিন এটা তোকে এসে
Mr.
Careful.
Hearing for this. View the matter consideration under the same heading in the daily supplement.
না এটা ফেরত দিয়ে একদম
21st you said? 21st,
21st, Mr. Mukherjee said.
21st.
21st. 21st you said, Mr. Mukherjee? No, it's 21st.
21st এ বলেছে।
Item number 22.
Lord, I am for the writ petitioner respondent.
Lordship, I beg to appear on behalf of the CBI. I'm being led by learned deputy secretary.
Lord, I am led by Mr. Bhattacharya. He is online.
My lord, with deepest of respect, Lord, I would like to file an affidavit to this application to disclose many more facts which are necessary for the purpose of the adjudication.
Which application, Mr. Bhattacharya?
The application of the West Bengal Board of Primary Education, being can number 1, Lord, I have to use an affidavit to this.
Yes, Mr. Gupta.
That if he wants to use an affidavit, I cannot oppose that.
Heard Mr. Gupta, learned senior advocate appearing for the appellant board. Stop, Mr. Bhattacharya, learned senior advocate, appearing for the writ petitioners.
Yes.
Writ petitioners stroke respondents. Please for leave to file an affidavit in opposition to the application being Can 1 of 2023 filed on behalf of the board. Stop. Such prayer is considered and allowed. Stop. Let such affidavit in opposition be filed within.
সুদীপ্ত কতদিন নেবে?
2 weeks, my lord.
Within 2 weeks. Stop. Reply thereto if any be filed. Within a week thereafter.
2 weeks. 2 weeks again.
2 weeks.
Board.
Release the matter for further consideration 4 weeks hence. Stop. The interim order passed earlier is extended till the end of March.
Yes.
Can 2 has been disposed of.
Can to, my lord, by
Oh, no, it addition of
it has been all been rejected.
ওনাদের অ্যাপিয়ারেন্স গুলো দিয়ে
অর্ডার শিট তো পেয়ে যাবেন।
My lord, the returnable
কত বললাম 2 weeks 3 weeks 2 weeks আর 2 weeks
consider further consideration 4 weeks.
2 weeks বলেছে আজকে কত তারিখ 9 তারিখ মার্চের 9 তারিখ ঠিক আছে মার্চের এন্ড অবধি তো
কবে my lord, matter will be returnable?
4 weeks
My lord, kindly, kind enough to fix any date. The matter is some.
if he doesn't come you remind us we
My
will include.
Item number 22.
শান্ত যাও এখন প্রাইমারি অ্যাপয়েন্টমেন্ট
কি আই আনসারিং
answering কিছু what is this one?
Here, matter relates to transfer of a teacher, my lord. Initially, the prayer for transfer was returned back on the ground of single teacher. I approached this honorable court. This honorable court set aside the order and directed the authority to process my application and to give transfer if I am otherwise eligible. And authority also directed the authority resultant vacancy to be filled up by a regular process. Now, my lord, since they did not take any steps, I file a contempt application. But in the contempt application, the learned single judge varied from the original order. I recall the earlier order and thereafter directed the state authority to arrange for alternate arrangement for that particular post. If the alternate arrangement is available, then and then only transfer will be effected. For challenging the same, I prefer this appeal.
Why do you say altered the order?
Yes, my initial order was setting aside the decision of the authority, directed them to process my application so that transfer may be effected. But at the time of hearing of the contempt application, varied from the original order.
You want to use any opposition to this?
One primary
this issue has already been
objection
decided.
I'm taking.
No, do you want to use any opposition or we take it up for you?
We will file an opposition.
Yes.
Because, but only one thing,
But
I have objection
Yes.
to the fact that my learned friend has written in his stay application in 2 or 3 places with regard to the Honorable Learned Single Judge, that there was a non-application of mind. This type of, we do not.
That I will check. If that is there, I shall withdraw that comment. Certainly,
It cannot be, we might differ with the order, we might prefer an appeal, but to.
If it is there, that is absolutely inadvertent.
Paragraph 9, paragraph 13.
Following the regular paragraphs, that is why that has been given. Yes, if it is there, it is a mistake on my part. Now, this issue has been settled by
the petition, Mr. Badi.
I myself drafted the petition.
Kindly
Not
see paragraph
expected,
9,
sir.
paragraph 13.
This is not expected. You check it up on the next day when you are fixing. You will you on the basis of your prayer we direct expansion of this agreement. Ashok,
Malat, one thing, Malat.
It's a limitation.
Yes, Malat.
That has been allowed.
No, perhaps not, Malat. It was hard, but not allowed.
How many days delay?
It's a delay of 132 days, according to my calculation, Malat.
What is the position?
132 days.
My lord.
But it is in time.
Lead was granted, bole he said.
No, appeal is against the orders of contempt. Two orders are there.
Lead was granted without certificate. You know, he said.
Where is your limitation application? You have served upon all.
Yes,
No,
Malat.
no.
Yes,
Only this state petition. Where?
You
the memo bill and read petition.
Section 5, why commission is not there? Commission is not there. Commission is a party, no?
Yes, my lord.
But you have not made commission a party.
It is only can 2.
You have made Hossein Ali.
No, Malat, I am coming against the contempt application. This appeal was filed against the contempt application. So only the contemners are party, my lord.
Contemners, nobody from the commission.
No,
because
because
the
it was
did not reach the commission. It
Yes.
was returned by the district
District
inspector
level,
of schools. Had the district inspector of schools allowed it, then it would have been forwarded to the commission.
You are not there in this appeal.
No, but
Yes,
my
ma'am.
learned friend has served copy on me. That is why I
he requested my lord.
lord,
He
in-
requested me, that's why I served a copy.
My lord, in that event, my lord,
there was a
this
direction of
contempt
the
petition
court.
is not maintainable. I am, my lord, because of the fact that intra-court appeal, my lord, and he has to take it as a, my lord, principal order. And that appeal in the amity. Otherwise, my lord, only the contemners are party in the proceedings. The section 19 of the Contempt Act will come into force. That is another proceedings, my lord.
My lord, identical issue considered by this honorable court, the coordinate bench.
It is also, my lord, the honorable Supreme Court also.
Absolutely identical issue, my lord. My lord, I last
In
occasion-
that event, my lord, if this
last
contempt
occasion
petition,
I submitted.
File your opposition.
My lord.
Section 5, then we will consider.
my lord, section 5 is not here.
My lord,
Can 2 only served, you see here.
Just show us the order, Bosudi. Show us the order.
my lord, order of the my lord, coordinate bench or my lord, the impugn order, my lord.
Have you given the section 5 copy to him?
My lord, he have bring different brief, my lord.
Counter.
My lord, I have served the copy.
Dharavana.
Yes, this
Right, this Rupak. Yes, yes. Dekchida.
You are opposing that, Mr. Shah.
My lord.
You are opposing that.
My lord, delay. No. In section 5, my lord, part.
Upon
Can I
hearing
leave, my
that
lord? I never.
After, upon clarification, that on 22nd December 2023,
You are not there, Dr.
no court
Patro.
directed to serve upon us. Your lordship directed to serve upon us.
The last occasion, Mr.
22nd December.
Dr. Patro appeared and said that I missed the brief and that is why your lordship directed me to serve. But he was unaware about whether he was party or not. Since it's a transfer matter, but he assumed that he was a party.
Point out to the court that
So are you opposing the section 5?
section 5 I never have. I'm not opposed.
Upon hearing
Cannot
the
allow.
advocates and appearing for the respective parties and considering the materials on record, we are satisfied with the explanation given towards the delay in preferring the appeal. Stop. Accordingly, such delay is condoned. Next para. And accordingly, such delay is condoned, then the application being ato is disposed of. the respondents would be at liberty to file their affidavit in opposition to the application being Can 2 of 2023 filed in connection with the appeal within a period of 2 weeks from date. Reply thereto, if any, be filed within a week thereafter. List the matter for further consideration, 4 weeks since. Yes. Next. Yes, Commissioner and Dr. Patra. Mr. Patra, Dr. Patra, we are not including you then. On the application, you come.
Yes.
ওনার সাহার নাম দিয়ে দেবে আর বাড়ি। Yes, next.
On a matter will appear under the heading application.
Yes.
This is my affidavit of service, my lord.
Who is opposing you?
I am for the state matter.
My lord, last occasion, your lordship directed me, school was not served. Your lordship directed me, my lord, service has been effected.
I am for the commission.
My lord, this is the transfer, general transfer application of a school teacher. My lord, appellant has joined in the service in the year 2007. And my lord, his subject is, my lord, his subject is English. My lord, the appellant successfully served the school, and in the year my lord, 2021, my lord, appellant seeks a application by way of general transfer. My lord, when application, my lord, your lordship find my
general transfer. What is that? Rule 3.
My lord,
general transfer under which rule? Rule
my
4.
lord, group 10B of the School Service Commission Act. Rule.
Oh.
A rule is framed 2015, and my lord, original section is 10B of the School Service.
What is the rule? Rule which rule? Rule 3 or rule 4?
Rule 4.
Rule 4, my lord.
Is on own seeking.
On seeking transfer.
Yes.
On seeking transfer.
After completion of 5 years.
After completion 5 years.
Ground was?
Medical ground of spouse and child.
Achha.
Which
Now
is
school adopted a resolution denying
Yes.
no objection.
But no, school is arbitrarily rejected my application. I am not a single teacher. Generally, my lord, embargo single subject.
No, the court earlier directed.
Yes.
Directed to supply the copy of
to communicate the reason from the said resolution to the petitioner. Have you received?
My lord, I have, my lord, received.
Against this order you have
Yes,
come.
yes. My lord, kindly see, my lord, application, my lord, 2, page number 36. My lord, that is my online circulation of my application.
Yes.
My lord, from backward, my lord, kindly see table number 6, my lord. First application is made on, my lord, from bottom to top, my lord. 16th of August 2021. Applicant to HY. HY to the applicant, my lord. Next is the HY to applicant. Reason is application
for the school.
But school I have served. Service is affected. But in the trial court, school not appeared, but their conduct is, my lord, very much arbitrary. Which is why, my lord, I may be restrained by some embargo that I am a single teacher or 10% or I am medically unfit. They make it, I only pray before your lordship, my application be processed. I may be rejected by the school by any of the ground, any of the DI.
Then they have not complied with the court's order.
Yes.
So to go in contempt, why in
So, my lord, that purpose is not fulfilled, my lord. My lord, kindly see, my lord, only that purpose, honorable trial court is directed me to the reason be given. My lord, reason I know. It is known to me.
Communicate. You have not been communicated.
Communicated, my lord, reason I know. My lord, my case before you, my lord, reason.
Where is the reason?
Reason, my lord, I have stated in my application. It has not been forwarded, but my lord, reason is, my lord, we shall not issue any NOC henceforth. But they are not following any rules and regulations. We are not releasing, but there is some rules. There is some rules on the general transfer. But it is, since I have completed the certain criteria, I may be eligible for transfer. I may be rejected by the authority. Maybe. But my application should be considered by the authority.
They can refuse no objection.
Yes, refuse no objection.
So that is the decision which the court has asked for production and communication.
communication, my lord.
Communicate that portion of the
My
resolution.
lord, that purpose, that is not fulfilling, my lord. They are only simple communication, my lord.
What prayer do you want?
I only praying before your lordship, my lord, give me liberty to apply a fresh, and authority should consider accordance with law. That prayer I am only wishes to your lord. Since, my lord, there is no application is pending, my lord, they have refused my application on the ground of that managing committee take a decision. Henceforth, no teacher will be transferred from the school. It is well known to the writ petition. In trial court, I have I have emphasized.
Where is that order?
But that order, but it is the managing committee decision. It should not be. But I know it has been communicated. But however, trial court this point has taken. However, trial court directed only give the reason. Reason I know that they will not follow any rules and regulation. They will not consider.
That has to be affirmed by the court now. That court wants to see that portion of the resolution. Your argument before the court was that I have been kept in the dark. No communication, nothing. That is why court passed the order.
That is what better communication, but that purpose will not fulfill. But since it's the appeal court,
so then when the purpose is not fulfilled, you have other avenues open. Why you are coming to us?
My lord, only, that is true, my lord, subsequent, my lord.
Unless your application is rejected by resolution, can we ask you that make a fresh application that will consider? We have to either set aside that order or we have to consider the validity of the order.
Lordship,
and if we find no objection has been wrongly refused, we will ask them to give you no objection.
Lordship, which is why, my lord, I have served notice. Which is why, my lord, I served notice. They should come forward, and my lord, reason should show your lordship. What reason, though? Why? What reason?
That is the duty. That will be the court, the first court which passed the order. Will enforce compliance.
My lord, compliance. My lord,
appeal court cannot enforce compliance.
Subject to my lord correction.
Yes, Mr. You can also. Which school is this?
No, my lord, the application has been rejected, or my lord, the refused, no objection, it has been refused by the school authority. It did not reach the commission. So, my lord, the ball has not reached my court. So, my lord, I have no control. Now, my
lord, only which is why, my lord, I am. There is no reason at all.
But he has not stated the reason.
File the writ, you come to page 20, you file the writ seeking a direction to set aside the remark made by the head of institution on 22nd February 2022.
That remark,
where that remark was given in the general transfer application of the petitioner dated such and such. Where is that remark?
Well, a remark is that remark that school is not issuing any NOC. That remark I want to. Well, there must be some reason. That is why, my lord, I am before your lordship. Well, I am not a single teacher. Admittedly, I have applied in medical ground. Well, there are some rules and regulations. Medical ground, they ought to consider my case through proper channel. Proper channel.
এখন ওরা যদি না পাঠায় একটা কজ অফ অ্যাকশন এবং যদি এটা রিজেক্ট করে সেটা একটা রিজেক্ট না পাঠায় সেটার জন্য অ্যাপিল কোর্ট কি করে? হ্যাঁ সেই কন্টেন্ট থাকে।
The difficulty is one of the reason remarks given here. But it is not that the school authority is not issuing the NOC. The remarks is as per the resolution of the school, it cannot be forwarded your prayer. That is the remark. Why it cannot be forwarded?
Where is that remark?
বলেছে তো অর্ডার আছে page 36 of the stay petition. Your lordship kindly sees the serial number 1.
What is this? What is this?
This is the printout taken from the Utsosi portal. Utsosi portal. This application, this transfer process was being conducted under the Utsosi portal. The candidates had to apply under Utsosi portal, and everything the steps taken pursuant to that application, they are reflecting here, it should be seen from the bottom portion. Your lordship kindly comes the bottom portion, the serial number 6. Forwarded, but this was the earlier application. His latest application is, your lordship will find at serial number 2. Forwarded on 9th February 2022 from the applicant to the HY, that is the head of the institution. Then, my lord, that prayer for, my lord, transfer was backwarded by the head of the institution to the applicant with the remarks, as per MC resolution dated 21st February 2022, I cannot forwarded your prayer. My lord, what was the
My lord, I am only.
What was the resolution? Was that resolution
Only that is why.
not for issuing NOC or for any other reason?
There must be, my lord, there must be some reason that I am back subject. There must be some reason that I am a single teacher. They are 10% or below. My lord,
This was the case before the writ court. My lord, the learned single judge, my lord, directed the school authority to, my lord, supply him the copy of the resolution.
Consider this is a court of appeal. Now here you have placed the order. Now if there is any error or fault on the part of, or in the order, then appeal court will interfere.
Subject to, my lord, correction, but my prayer is very clear to only set aside that remark and apply a, give me liberty, apply a phrase. That has not been considered. This is
when will that stage come? After communication, na? After the court gets the communication of the resolution, then the court will set aside that. Unless that communication reaches the court, what is the purpose for the appeal? You can file a contempt and compel and say before the court that the person may be summoned. We understand that you are having you thought that you will get a remedy before the appeal court, they will come. We are not exercising contempt.
No, I am not saying contempt. My lord, only, my lord, I am seeking before your lordship, only, my lord, this much prayer. My lord, only this much prayer. I am, my lord, only, my lord, give me liberty to apply a fresh, and that should be considered in accordance with law. Your entire purpose will be fulfilled. That's the rule, my lord. If I am eligible, HY consider.
When the proposition for fresh application come,
well, now he can apply.
Wait, if it is a matter that it has been left unattended, then the question is, here a resolution taken.
Resolution, my lord, if the resolution is arbitrary, that I know about the fate of the resolution is, my lord, henceforth no teacher. My lord, even medical ground, though there is no medical test at all. There is no medical test at all.
When did they receive the letter?
My lord,
when did they receive?
My lord, I have a track record is there, my lord. My lord, two affidavit of service, my lord.
When did they receive?
অর্ডারটা কমিউনিকেট হচ্ছে এটা বলছি
না ওইটা আরেকটা affidavit of service আছে
অ্যাপ্লিকেশনটা এই যদি
show us the rule. Where is the rule that
yes my lord, 2nd of February they have received, my lord. 2nd of February, my lord, begin
2nd of February, where show us under the rule that after, if no objection granted,
yes,
if no objection refused, then what is the procedure prescribed?
My lord, so far medical ground is concerned, preferred ground is concerned, my lord, as per rule, medical verification of the candidate is required. They are duty bound to conduct a medical verification by the past BOMH, by the conduct.
My lord,
service
you have not understood. If school refuse to give no objection, then what is the prescription of the law? School said,
I can, my lord, I can, it is there is.
Mr. Bandyopadhyay, is there any provision to apply directly?
No, my lord, he is praying for liberty to file, my lord, apply afresh. My lord, there is no requirement of liberty. Because, my lord, once his application for transfer, the last application has been
made, has to be rejected.
Rejected. It has been rejected. He can apply afresh. There is no embargo, my lord. No liberty from the court is required.
So it will be again
rejected. Again rejected on that way, on the same score.
On the same score.
Same score, my lord, at least some.
How you will be benefited? Anyway, when you are out, let us see. We will. Affidavit of service filed by the appellant be kept on record. Stop. In spite of service, no one appears today on behalf of the school authorities. Stop. To give a further opportunity to the school authorities to appear and contest, the matter stands adjourned. Release the matter for further consideration. in the daily supplementary list of this court on 29th February. The appellant is directed to communicate this order immediately to the respondent numbers 5 and 6 and to affirm an affidavit of service afresh and to affirm an affidavit of service on the returnable date and to file an affidavit of service on the returnable.
I'm extremely
extremely
grateful.
Sure.
Lordship, may I seek leave to move one urgent appeal tomorrow, Lordship. The urgency is on the Friday, Lordship, the learned LRTT has passed an order, and by which, Lordship, my appeal, which is preferred against the order of the Thika controller before the LRTT, and which is now the date has been given after a long time. Now, what is the prehension, Lordship? By this time, the taking the advantage of this, the property would be completely demolished for the purpose of construction of a multi-storied building on a Thika property, wherein I was there in possession by virtue of the other orders.
Your interim order we prayed for.
Interim order has been prayed for, and that has been without considering that it has been
When has been passed?
on Friday.
Friday. Last day in the
Last
evening,
Friday.
I have collected certificate copy.
And yesterday you obtained the certified copy, and now I got it prepared.
It will appear day after tomorrow, though.
Lordship.
Tomorrow.
When is there any apprehension of demolition?
Lordship, they have already started.
Already they have started demolition work.
Who is your other side?
Lordship, in LRTT, who was there? Private respondents were represented in LRTT.
The leave granted tomorrow. Serve upon everybody.
Lordship.
Yes, next.
My lord, may I seek lordship's leave to?
Why, madam, you people mention now, not in the first sitting of the court.
My lord, I came in the morning, my lord.
You mentioned in the morning.
I came before your lordship in the morning, but my lord took the item number 1, so I come now, lordship.
When was the order passed?
My lord, this is 26/8/2022. Lordship, difficulty is
26 August
2002. My lord, difficulty is they have highlighted some portion in the certified copy.
Sorry, you obtain the certified copy and file. There is no such urgency. Yes, call the list. Huh? 2 PM টা ডাকো একটা।
এটা কালকে দিতে বললাম।
I have, Mr. Mojumdar, we have a small motion. Yes, where is the petitioner? Mr. Roy.
Item 4. I am sorry,
Yes,
Milord, I could
item
not be
4.
here because the matter was going. So this is the affidavit. Lord,
Union of India.
yes, Lord. Lord, the revisional application has been preferred by the Union of India.
Yes.
Lord, against an order passed by the Central Administrative Tribunal, Kolkata bench. The thing is this, Lord, Lord, recruitment notification was issued by the Postal Department, Lord, in August 2023. In August 2023. Now, Lord, the drop-down list of school which are recognized, that was given in the portal. But, Lord, the respondent who passed from the Vishwabharati University, the class 10 standard, that was not in the portal. That was not included because it was not recognized by the Postal Department. That's why it was not recognized. Now, the tribunal, by an interim order, directed the authorities to take his application offline. That is the cause of grievance, Lord, to the concerned authorities, because that is not the system. Your Lordship, kindly have a look to the impugned order. Lord, this is dated, Lord.
Your notification.
Yes. Note recruitment notification. Yes. Well, that is quoted in the order itself. But I still not show to your Lordship. Lord. Yes. Blood, page 14. This is blood, with regard to blood, filling up of vacancies of Gramin Dak Shebak, GDS.
Now, when was the last date for online application?
Blood, yes, blood.
Notification was 31st July.
Yes.
When was the last
Last date, blood, I just.
You obtained from Vishwabharati?
Santiniketa Vishwabharati, my lord.
Vishwabharati is not recognized.
So that school is not recognized, blood. Blood, I have annexed. This is school. The school is not recognized, blood. Blood, I have annexed the blood list of recognized school which was included in the portal. The Vishwabharati school is not appearing.
It is not a case of fraud, Mr. Roy, that no such school exists or no such school has existence. As the tribunal has said, you accept it, we will consider. How you are prejudiced?
Tribunal has, because online application was off by now, by that time, Lord. Therefore, tribunal directed.
Keep it on record, you accept it. Ultimately, if they cannot substantiate, you win, you throw away that application.
No, if the school is not at all recognized,
you will throw away. That is why tribunal has fixed on 6 September. 6 September it has been fixed.
But Lord, your Lordship kindly appreciate one thing, Lord, the portal which includes the recognized school.
It is recognized by the state of West Bengal.
Or India, or Union territories.
No, Vishwabharati is recognized by state of West Bengal.
Yes, I have the document to that.
No,
I obtained the website.
You come to, there is no pagination. Come to para 3 of the order into.
Yes.
Tribunal observed that.
Paragraph 3.
Yes.
The applicant has passed the school certificate examination from Vishwabharati University and the said examination conducted by the is recognized by the state government, that is state of West Bengal. Where from?
No, my lord. The reply was filed on 13th of September 2023. Rejoinder was filed. Everything.
1 minute. Now you come to page 18.
18. Secondary school examination pass.
Secondary school examination pass certificate of 10th standard having passed in mathematics, English.
Yes.
Conducted by recognized board of school education by government of India.
Yes.
/ state government.
Right.
Union territory.
Right.
State government is there.
So recognized board of school education.
By this, that is paragraph 2 of your order, where the 5.2 has been quoted. Kindly see clause B. Secondary school pass certificate of 10th standard having passed in mathematics has conducted by a recognized board by the government of India, state government.
Right. But the recognized schools, I have given the list.
So that may be wrong on your part. Maybe your drop-down list erroneously left out this institution. For that, why they will suffer?
No, your Lordship, kindly have a look to the recognized schools. The school is not recognized according to us.
Recognized by state of West Bengal.
No, it is neither recognized by state of West Bengal nor recognized by.
Where have you stated?
Your Lordship sees the. Just
the advertisement.
Yeah, have you got the certificate?
Lord, kindly see, Lord.
I have the document to the extent.
Your certificate, not
Lord, if your Lordship kindly takes page 30.
At present, my lord, I have not one, but my lord, I have the
page 33, if your Lordship kindly.
List of recognized boards by state. Yes.
Lord, here, according to this, Lord, this is instructed by the Ministry of Communication, Department of Post. According to this, the portal was uploaded. The recognized schools were uploaded. He could not fill up the online application because his school names were not there.
So this you have depended upon a list sent by Ministry of Communications.
Right.
That is your own ministry, which states West Bengal has Board of Secondary Education, Rabindranath Open Schooling, and madrasa education.
Yes. Yes.
So those are recognized by state. Those are not recognized by central government.
No, my lord, state recognition
Page
list.
40, these are all state recognized. List of recognized board by state government. Now you have not included Vishwabharat.
No, my lord. And another page, your lordship kindly have a look, not another page, your lordship have a look. The state recognition in support of the school where the respondent studied is also not there. Lord, as I find, Lord, your lordship kindly see. Lord.
Did you file any vacating application?
No.
Then it was what happened thereafter? 6 September.
Thereafter, on 13th of September 2023, when a reply was filed and a rejoinder was filed on 4th of October 2023. The matter was fixed for my lord, reply rejoinder is complete, my lord. That was fixed for hearing on Monday, my lord, on 12th. Final hearing.
12th?
12th of February.
12th of February went to us to
Monday.
12th of February is open. Huh? Open is Saraswati.
It is
a government school. And this government school, my lord, and I have the document on the website, my lord. My lord, kindly see, my lord, this school was recognized by the West Bengal state government.
কোথায় পেলি আমাকে একটা দে আমাকে একটা দে
I তোমার serial number 28.
This is West Bengal Council of Higher Secondary.
My equivalent boards, kindly see the matter. And West Bengal government website, it is not appearing. Serial number 28.
This was there in your original application.
Yes, yes.
in the rejoinder.
In the rejoinder, I have mentioned.
But my lord, kindly see page 51.
Page 51.
Page 51. Well, this is a list of Ministry of Human Resource Development. The boards which are recognized. This board, not even if other schools of West Bengal are there, but this school did not find its place.
No, government owned.
Government portal is there.
Actually, school are aided, unaided, and government funded by government, owned and run by the government.
That's good.
That which is aided school, that is run and managed by the supervised by the board. Now, government owned. Have you included the government to which school are directly run by the government?
এটা হচ্ছে লিস্ট অফ রিকগনাইজড বোর্ড বোর্ড বাই স্টেট যেটা স্টেট গভর্নমেন্ট এইটা ওরা স্টেট গভর্নমেন্টের কি সার্কুলার দিয়েছে তো পোস্টু বোর্ডের নাম দিয়েছে স্কুলের নাম বিশ্বভারতীটা হচ্ছে ইকুইভ্যালেন্ট টু বোর্ড হ্যাঁ বিশ্বভারতী হ্যাঁ অটোনোমাস বডি না স্কুলটা হচ্ছে বিশ্বভারতী স্কুলটার নাম হচ্ছে what is the name of your school?
Pat Bhavan, and the board is not, they are challenging the board, Vishwabharati board. The name of the school is Pat Bhavan.
Where do we find it? Pat Bhavan. He was passed matriculation from, you have said you have passed matriculation from Vishwabharati University.
University board, my lord, that is board.
Give a copy to then you they received your representation.
They accepted, my lord. We are submitted our application, and my lord, the matter, my lord, they filed their October rejoinder. We have filed a reply.
The present writ petition has been preferred challenging an order dated 18th of August 2023, passed by the Learned Central Administrative Tribunal, Kolkata, in the original application being OA/1061/2023 by the said order. the learned tribunal granted an ad interim relief, allowing the applicant stroke respondent herein to submit his application in response to the notification dated 31st of July 2023, and the respondents therein were directed to accept the application through offline mode or to make an arrangement to accept his application through online before the last date of submission of application.
Last date period 23rd
Royal
of August
Advocate
2020.
appearing for the
Order হয়েছিল 18th August.
petitioners
Order date কবে?
18th August.
submits that the institution from where the petition respondent allegedly obtained the matriculation, passed the matriculation passed the secondary school examination is not recognized by the state government. In support of such contention, he has placed reliance upon the letter dated 21st January 2022 issued by the issued from the Ministry of Communications wherein the wherein the Vishwabharati wherein the Vishwabharati wherein Vishwabharati board ki wherein the name of the Vishwabharati does not feature. Does not appear. Stop. And accordingly, the name of the said board was not included in the drop-down list Stop. Failing to appreciate such fact, failing to appreciate such fact, the learned tribunal erroneously directed the authorities to accept the application for the post through offline mode. আরেকটা document কি ব্যাপার? আরেকটা document। না, না, আরেকটা বলবেন।
ওটা হচ্ছে লিস্টটা হচ্ছে পেজ 36 থেকে শুরু 11 হচ্ছে 45 থেকে
Stop. He further submits no drop down list. Stop. Per contra, Mr. Bhattacharjee, learned advocate, assisted by Mr. Monirujjaman, learned advocate, Monirujjaman, appearing for the respondent stroke applicant, submits that Vishwabharati West Bengal is equivalent to the West Bengal Council of is a equivalent board is equivalent to the West Bengal Council of Higher Secondary. Right? It is an equivalent board considered to be by the
it is in the portal of the West Bengal government, but it is equivalent to the West Bengal Board of Higher Secondary Council. And my lord,
equivalent to
I have
the board of West
I have
Bengal
also my lord, list of
higher
recognized board.
secondary education.
I have also my lord, submitted my lord, the list of the
How
recognized
you are saying it is a board equivalent to the council?
council. My lord, this is the my lord, West Bengal government. My lord, this is West Bengal board.
আচ্ছা ছেড়ে দাও।
Well, kindly see page 40.
And my lord, the list of kindly see the list of the register list of the my lord, the registered boards at serial number 70. They are also on
serial number
70.
Where from did you get it?
My lord, the second page, my lord, serial
কে ইস্যু করেছিল? Who issued this?
West Bengal Joint Entrance Board was issued this, my lord. That is
আচ্ছা,
from their
Mr.
website.
Bhattacharya submits that the ওইটা বসি। If Mr. submits that the petition that the school that the matriculation examination was conducted by the Vishwabharati, which is recognized by the state government, that is, which is recognized by the state of West Bengal, and is recognized by the state of West Bengal. Stop.
Ministry of Ministry of Human Resource and Development equivalent board.
Now, what's the contention that is recognized by stop. He further submits that the interim order was passed on 18th of August 2023 and upon exchange of reply and rejoinder, the matter has been fixed for final hearing on 12th of February 2024. Heard the learned advocates appealed respond and consider the materials on record. On the basis upon considering the notification, upon considering the notification and other relevant records, the learned tribunal arrived at a prima facie finding arrived at a prima facie finding towards grant of an ad interim order, more so when the denial of such relief would render prima facie ground. The learned tribunal arrived at a prima facie finding ad interim order in favor of the respondent, more so when the denial of such relief would have caused irreparable loss. Stop. We have also been informed that the pleadings have been exchanged by the parties and the matter has been fixed for final hearing on 12th of February. In answer to our query, Mr. Roy also submits that no application for vacating the interim order passed on 18th of August 2023 was filed by the petitioners. In the said conspectus, we are not inclined to interfere with the discretion exercised by the learned tribunal in favor of the respondent. Accordingly, the leave petition being such and such is dismissed. There shall however
that there is a delay in filing the application, revisional application, that can be conveyed.
You filed any application?
Yes.
Affidavit of service leakage?
Yes.
The present application challenging such Tapabrata. As we have invited Mr. Roy Learned Advocate to advance his argument on merits of the matter, The delay in filing the present application is condoned, and the application being such and such is allowed. Yes,
Yeah.
next.
Please.
All points are kept open before the tribunal, Your Lordship.
Only on the prima facie finding as regards grant of ad interim we have said.
All right, I'm grateful to her.
কি আর শেষ হবে বলো? কি আবার পাঠাতে চলে যাবে। Where is your other side, Mr. Mujumdar? ওই কাগজগুলো ভেতর রেখে দেবো। Yes.
This is a case of promotion on having passed examinations. But after we were promoted, the department wanted to bring in certain criteria for the purpose of confirming those examinations.
Yes.
But the examination conducting agency of the department said that this cannot be applied retrospectively. The Board of Revenue observed that this cannot be applied retrospectively.
Still they applied.
Still they applied.
As such, you are here.
As such, we were before the tribunal first.
Yes.
And what is the difference? That there were cut-off marks in the examination which we took. Which we took. Now, after we had passed such examinations or papers, the ministry wanted to apply a higher cut-off marks which are applicable for higher posts. We said, we have already passed. How can we apply a test retrospectively? Because an action is concluded. We had been promoted. So this is not even a case of retrospective operation. Rather, this is a case of retroactiveness. An action completed sought to be reopened is retroactive.
Yes.
The tribunal upheld the memorandum of the government by which they wanted to apply this to us. But this is the short issue.
I see. Now you have not yet been confirmed in the promotional.
No, we were on ad hoc or provisional basis. They wanted us to be downgraded and reconduct the examination. To that extent, there is an interim order passed by this Hon'ble Court directing maintenance of status quo.
For which they have filed a beginning application.
But the result...
There must have been a bunch of persons who passed that selection.
Yes, not the resultant effect is 2. But there are juniors who have surpassed me, but I continue to stagnate.
Yes. They are parties to this petition.
No, we don't claim a supersession of our rights. Not we only want our promotion to be regularized so that we can follow thereafter.
Not about seniority. Yes.
I'm not.
What is the promotional post?
Inspector.
And the feeder is?
But the feeder is really twofold. Not one is tax assistant, the other is senior tax assistant. that senior tax assistant is really an upgraded post of tax assistant arising out of restructurization of cadre.
Yes.
Now it's LDC to UDC, UDC to inspectors, senior tax assistant, then inspectors, like that. And but please have a not we were promoted to senior tax assistant. That's an admitted position. That was in 2003.
No, you were holding the post of now inspector.
Now inspectors.
Now he's inspector.
So the
2003 we got promoted to senior tax assistants.
Restructured here.
That's a restructured clerical post.
So that promotion is not disputed.
That is not disputed.
So you have been promoted as senior tax assistant.
Yes.
And then you were promoted after when was the examination held?
No, this was conducted in between 2006 to 2007. We all became inspectors.
2006
to 7.
So this promotion is on unregularized promotion.
No, ad hoc basis.
Promotion on ad hoc basis.
Ad hoc.
How many of you are there?
No, the petitioners are 7, and there are intervener applicants who are
petitioner হচ্ছে 9.
There are 9 lead petitioners and
আমি বলে দিচ্ছি.
Very good. And interveners. So show us that start with the notification for written test.
My lord, please have a look at page 48. Now, this is requiring higher marks to be obtained.
48. So this is the notification for?
This is the notification for obtaining higher marks.
Where is the earlier notification?
Oh, earlier promotion.
By virtue of which you appeared?
Oh, no, I appeared. Please have a look at page. No, there is I have prepared a very short compilation, maybe handy for your lordship. There are compilation again.
ওই যে তোমার ওখানে আছে, ডান দিকে আছে. আচ্ছা, অ্যাপ্লিকেন্টস হচ্ছে 17 জন, ইন্টারভিনার্স। হ্যাঁ, নিচ্ছি। কপি দাও।
Please have a look at 29 to 27.
এটা কোন কপি না?
Reginate class.
ও আপনি আমারটা নিন, আমার মার্ক মানে আন্ডারলাইন করা আছে। বলো তুমি কোথায় কোথায় দেখাবে বলো।
29 to 29.
এই
Following senior tax assistant stenographer grade 2 who have qualified in the written test held on 13 December 2005 for promotion in the post of inspector, PO is preventive officer, and so on ad hoc basis are hereby directed to appear before the departmental promotion on 13 December 2005 from 3 p.m. for this is the examination process we can shoot.
বার করে দিচ্ছি। কোনটা দেখাচ্ছ বলো? 29।
29.
তাপস আদিত্য।
পেপার বুক মিলার পেজ 237।
In this list, petitioners are all there.
Yes.
তাপস আদিত্য। তারপর হচ্ছে বাসুদেব কর্মকারী
যে আছে 9 নম্বর বাসুদেব
কর্মকার, বিশ্বজিৎ দাস।
প্রথম হচ্ছে আদিত্য। Aditya is not there.
There are various promotion orders. 237 is one.
Serial number page 31, serial number 20.
23, not it's analogous to page 239 of the paper book. Please see page 31 of the compilation. Not it's almost at the middle portion of the first box, it's Tapos Aditya.
Yes, yes.
But there are various lists published from time to time during this
So you
election
appeared in the departmental promotional exam. What is this called?
examination.
Acha. Then what happened?
So that it comprised of 3 phases. Not one was written test, physical examination, and then oral interview. So not all these 3 phases were concluded. We were promoted provisionally.
Where is the provisional promotional order?
31. No, just give me 2 minutes.
Now, these are appearing at page. These are 29 to 37. These are the 29 to 37. Not this there.
33. No, it is following senior taxes. Ad hoc is here.
29 kindly sees, Mr. Mojumdar, please. 29. Page 29 of that compilation. Inspector PO.
For promotion, yes.
No.
The following senior tax assistants who have qualified on ad hoc basis.
On ad hoc basis. Directed to appear our
এই পরীক্ষায় বসে এই পরীক্ষায় সাকসেসফুল
13 December 2005.
So after this completion, you applied for confirmation in the promotional post.
No. When we were holding this promotional rank on provisional basis or ad hoc basis, they wanted to apply a particular circular of 2004, which had not been acted upon during our examination process, for the purpose of finding out the qualifying marks having obtained or not.
এর আগে you in your list of dates you have not given
Yes, yes, it is there.
When the test was held, etc., etc.
Yes, yes, it's there. If your lordship kindly takes note the list of dates.
This draft notification. Actual.
And it takes note the 3rd page of the list of dates. But in that compilation, there is a list of dates prepared with reference to page number.
Page number of the paper book.
Now, what does the circular say? Page 48. You are placing page 48.
Please see note the date of the circular. It's 20th August 2004. Before we were promoted.
This was, your promotion was on
20th August 2004 is page 23 of the compilation. Page 23.
Of 2005.
No,
promotion was in 2005.
5 to
6.
5 to 7, roughly.
Very good. Then came this page 48.
Why I did not place it before? Because they did not apply this when this promotional exercise was undertaken. I'll show to your lordship that they had consciously waived this provision when the promotional exercise was undertaken. I'll show to your lordship that. But not, this is stepping in our way. 20th August 2004. Departmental examinations for promotion of ministerial officers to the higher grade to be held in the month of August 2004 and September 2004. So this was restricted to a particular exercise for examinations held in August and September 2004.
Clarification to SC.
Clarifications regarding eligibility, relaxation to SC/ST candidates, etc.
So there was no such memo at the time you participated.
This was not brought into action insofar as my promotional exercise was undertaken.
But it was existing on the date of your promotion.
For a particular one-time dispensation and for relaxation of SC/STs.
One-time dispensation, what did you mean by that?
Higher grade, please see, subject is departmental examinations for promotion of ministerial officers to the higher grade to be held in the month of August 2004 and September 2004. And this is with regard to clarifications regarding eligibility, relaxation to SC/ST candidates. So this was meant for a specific purpose. Board has received a reference from Central Excise Cochin for clarification on the following points. A. 1. Qualifying service for appearing in departmental examinations for different cadres, that is LDC, tax assistant, senior tax assistant, stenos. 2. Whether any relaxation in qualifying marks can be granted to SC/ST. 3. Whether an officer is required to appear for the same paper again in departmental promotion exams for different cadres if qualifying marks required and obtained is less in the lower cadre and required more in the higher grade in the same paper. Before cadre restructuring, 2 advance increments were admissible to those LDCs who passed the. No, this is not necessary. This is paragraph 2. The issues have been examined in board and the following is clarified for information and guidance of all cadre controlling authorities. The eligibility criteria for promotion to higher grades have already been made clear in the new recruitment rules. No, this is not very relevant. Kindly comes to the next page, paragraph C. C is important. This is one which applies in my case or has been made applicable in my case. If a ministerial officer who has passed the paper in lower grade with the qualifying marks equal to the qualifying marks in the same paper for higher grade. Suppose not for the promotion to STA, I had to undertake examination in customs paper. Now we are on customs and excise department. Now I had got 50% marks. But for the same paper, the qualifying marks for higher grade is 65%. Say for the post of inspector, a customs paper is also a paper. But for the rank of inspector, the qualifying marks is 65%. So the first part of it deals with a situation where in the lower promotional rank, I had obtained 65% marks. If a ministerial officer who has passed the paper in lower grade with the qualifying marks equal to the qualifying marks in the same paper for higher grade, he may be exempted from appearing in the paper again for departmental examination for promotion to higher grade. I have obtained 65% when being promoted to STA. Now I am incumbent for inspector. I am exempted from appearance in that particular paper while I am appearing for the post of inspector.
So that
however,
in the 2 grades, that percentage was qualifying marks was how much?
In STA it was 50% for us. For higher rank of inspector, it was 65%.
So then you come under with, then you do not come, he may be, if you have obtained 65, you would be exempt.
Then I am exempted from appearing in the customs paper when I am incumbent for the rank of inspector.
Right.
Then the second sentence. However, if he has passed the paper but secured less than the qualifying marks required for higher grade, he has to appear and pass the same paper again in order to show improvement in his performance and knowledge. Now, not an STA is incumbent for the rank of inspector, but in the customs paper, he has obtained say 55 marks or 60 marks. Now I have to sit for that examination, reconfirm the paper, and then get promoted. Now, this was the circular introduced in 2004. Not introduced, clarified in 2004, but
so
not
what
introduced.
Was the qualifying mark for higher grade?
65.
Now, however, if he has passed the paper but secured less than the qualifying, you said
then the qualifying marks in the higher grade.
Yes, that is 65.
But I have passed with say 50% was the cutoff mark in the lower grade, in the same paper.
Then you have to sit afresh.
Sit afresh for the higher.
No, we are asking you how much did you obtain in the?
We obtained between 50 to
below 65.
Above 50, but below 65.
So if the circular applies, you are not entitled.
I have to reconfirm the examination.
Reconfirm the examination.
1st December 2009.
So your challenge is that this portion, this memo was not made applicable while your promotion was granted in 2005.
Because not this exercise was undertaken in 2009 for the first time.
What is their reply to such stand?
Let I just show to your lordship that it was to
You finish off. This is your first point.
This is my
Yes.
Then kindly turns back to page 47 once.
Yes.
Mr. Mundar, where is the original certificate? It is clarification.
Yes.
Original.
That's not there, neither here nor there. Please have a look at page 47.
If there is a original, then the clarificatory memo refers back to the date of the original circular.
But not the case is not, this was not applied. Whether clarification or not, please have a look at 47.
47 will clear the
page 47
of the paper book.
C এর সাথে parallelly পড়তে হয়।
Yes, what you are wanting to say.
Establishment Circular of 2009. Departmental examination for promotion of ministerial officers to the grade of senior tax assistant and inspectors of central excise preventive officers and examiners group C executive grade in narcotics department to be held in the month of January 2010 regarding, as intimated by NASEN is not the examination conducting agency, Chennai, Vide letter dated so and so dated 21/10/2009, the departmental examination for promotion of ministerial officers to the grade of senior tax assistant and inspectors of so and so will be held from 27th to 29 January 2010. Applications in the prescribed proforma from eligible candidates should reach the establishment department on or before 4/12/2009 positively, and after due date, no application will be accepted. Please see the next paragraph. Apart, it is seen from records that after 20th of August 2004, that's the document that I read just now, page 48. Some officers have been promoted to the grade of inspector, preventive officer, examiner without qualifying in paper 1 customs law and paper 3 administration with requisite marks of 65%, which is required in terms of ministry's letter of 20th August 2004. And the said officer should also apply in the prescribed proforma for this examination by 4th December 2009 positively. It is hereby clarified that those officers who have got promotion to the grade of inspector with less than 65% mark in paper 1 customs and 2 administration in departmental examination for promotion from LDC to UDC have to qualify in paper 1 customs and 3 administration with requisite marks in the instant examination to be held on 27 to 29. And this is the only and final chance. Otherwise, their cases are to be placed before the review departmental promotion committee for further decision. So what was sought to be reopened was an action already completed between 2006 to 5 to 7. In 2009, on the basis of that August 2004 circular. Whereas the department which undertook the promotional exercise in 2005 to 7 did not apply this circular.
On the contrary, declared as passed.
Yes. So what was the reason for giving you ad hoc?
But promotion has to be ad hoc at the first instance. Every promotion is ad hoc or provisional.
After written test, viva voce and everything ad hoc.
But then subject to confirmation, one is on probation for a certain length of time. Till such time, he'll be either provisional or ad hoc.
Maybe that your promotional matter relating to promotional not has been finalized.
No, that is subject to confirmation in the promotional rank. Not depending on the examination process. But I'll show to your lordship. Please have a look at page 266.
Yes.
This is dated 21st of March 2012. Subject is departmental examination for promotion to the grade of inspector, clarification regarding. Issued by the Ministry of Finance to the Director General of the Examination Conducting Agency. I am directed to state that the All India Customs Ministerial Officers Association Kolkata has raised a question as to the percentage of pass marks in respect of the officers who sat for the departmental examination held on 27th to 29th November 2003 for promotion to the grade of inspector and for whom the result of the examination was declared on 30th December 2003 vide Commissioner of Customs dated so and so.
Before your selection.
Before. The association has drawn the attention of the board to the following facts on the above issue. For the officers who took the above departmental promotion examination held on 2003, for their promotion to the grade of inspector, it has been stated that the question papers for the said examination had shown 40%, 50% as the pass marks for such promotion. This is apparently in tune with the board's instruction on departmental examinations as prevailing on the date of examination. The result of the above examination was published on December 2003. In conformity with the provisions of Note 2 below, Rule 20 of the draft notification of the rules and syllabus for departmental examinations, the officers were either declared passed or failed without indicating the marks obtained by them. Based on such passing of the departmental examination, some officers in Kolkata Customs were promoted to the grade of inspectors on ad hoc basis vide Commissioner of Customs letter of 2006. The board video letter number so and so dated 20th August 2004 issued instructions to the following extent. I need not reiterate the instruction. In view of the above, it is apparent that enhancement of qualifying marks for departmental examination should have been made effective with effect from 20th August 2004 and not from backdate, since there was mention about its retrospective application. It is however observed from the Nassens letter dated 16th October 2003 that they had raised the pass marks from 40% to 65% for departmental exams scheduled to be held in November 2003 for promotion to the grade of inspector and inspector examination. In view of the fact that the board had issued instructions for raising qualifications or pass marks on 2004 vide details in subpara 4 above, it is not clear as to how Nassen had increased such qualifying marks from retrospective date vide details in subparagraph 5 above. It is apparent that based on the Nassen's letter of 16th October 2003, Commissioner of Customs vide his letter dated 2009, read with the letter of 25/1/2010, had directed those officers who were earlier declared passed in the departmental examination held on 2003 with marks less than 65% promoted and subsequently promoted to the grade of inspector to reappear in those papers in which they had obtained lesser marks than 65%. Against such action of this commissionerate, the affected officers has moved the Honorable Cat Kolkata bench filed by Sri Taposh Aditya, and in the said case, the Honorable Cat had passed order of 1/4/2010 for maintenance of status quo as on the date of the order till the date on which the matter would appear before the said bench. In order to enable us to examine the issue raised by the All India Customs Ministerial Officers Association, Kolkata, keeping the relevant factual position into consideration, it is requested that clarification in para 2.6 above may kindly be furnished to the board urgently. So, how did Nassen clarify now? Please take page 266. Please see page 269.
But this was Mr. 267. This was dealing with the examination of 2003.
Who had been promoted to 2003 as STA, then they had become inspectors. We were all promoted to STAs by 2003.
Yes.
And this was specifically addressing the issue as raised by us. What happens to us who had been promoted as STA prior to 2003 and promoted as inspectors after 2003?
Yes.
Now please see page 269. The Central Board of Excise and Customs, with a letter of 13th August 2003, has authorized Nassen to conduct examination for promotion to the grade of inspector as in past. The board also decided that finalization of syllabus, etc., is to be carried up toward DG. Then next paragraph. Accordingly, DG Nation constituted a core group chaired by the director. The core group held a meeting on 15th October 2003 to finalize modalities of conducting various departmental examinations for promotion. The meeting decided the syllabi and modalities of the following examinations: promotion to inspector, promotion to Group C executive cadre in narcotics department, promotion to preventive officers, promotion to senior tax assistants. The schedule for the examinations, maximum pass marks and other conditions were prescribed in annexure enclosed with the minutes of the meeting. Thereafter, core committee headed by the Director General in the aforesaid meeting itself authorized RTI Nation Chennai to conduct this examination. It is further stated that from the subject, that is departmental examinations for the purpose of ministerial officers to the higher grade to be held in the month of August 2004 and September 2004, clarifications regarding eligibility, relaxation to SC/ST candidates, etc. of the letter dated 20th August 2004 issued VD number so and so by the Department of Revenue, that the clarifications were limited to these two examinations only. Therefore, the decisions taken by the core committee headed by the Director General on 15th October 2003 was based on the available records and decisions of the ministry. In view of the above facts, it appears that the question of retrospective application of clarifications dated 20th August 2004 does not arise.
Yes.
So the limb of the ministry understood that 2004 document to be a one-time dispensation and restricted to only that exercise of August and September 2004.
Which they did not exercise. 24.
Which they did not exercise when we took our examinations. And therefore in 2009 and 10 subsequently, when we were asked to reappear in the examination for the purpose of confirmation of the paper, but we objected. Because
we came to the court by way of the original application.
এটা তো বলছে না যে যদি স্ট্যান্ড টু এটা ওরা ক্লারিফিকেশন আছে যখন সামথিং আসবে কিন্তু থিং ইজ you came to the post of senior tax assistant in 2003. Then thereafter you came to the post of inspector in 2005.
5 to 7.
5 to 7. Yes. Yes. Now in 5 to 7, what was the promotional rule?
Not that cutoff of 50%.
Where do we get that?
Promotional rule.
Rule. Promotional rule.
This portion must not have been there. That you have to be.
No, it was not there.
Page 186. 186.
What percentage of marks they have to see here?
Yes.
186.
166.
186. These rules shall be
No, please see page 26 of the compilation, which is equivalent to page 243 of the paper. Please see 243 of the paper.
Yes.
This was on 17th March 2005, when the promotional exercise was going on. I am direct, this is by the Ministry of Finance to all the commissioners.
This is again clarification.
No, recruitment rules to change.
What was the recruitment rule?
Oh,
It's 186,
186.
186.
That's at 186.
6. এটাই কন্টিনিউ করে।
So this does not provide for any cutoff marks.
চলো অ্যাডমিট করেছে তুমি যেটা পড়ালে 269 269 এ অ্যাডমিট করেছে ইনিশিয়ালি देयर वाज नो কাট অফ
না কাট অফ তো ছিলই 260
পেজ 180 সিনিয়র ট্যাক্স অ্যাসিস্ট্যান্ট উইথ 2 ইয়ার্স রেগুলার সার্ভিসিং। এটা হচ্ছে প্রমোশন।
প্রমোশন হচ্ছে 66.2/3% বাই ডাইরেক্ট এবং 33.13 বাই প্রমোশন। এবার প্রমোশন হোয়াট ইজ দ্য
The percentage of marks for passing was notified at the time of examination. That's not prescribed in the rules. That your lordship will get at page 270. That's the letter which was that the clarificatory letter by Nessen.
269.
Yes, 269 at 270. The schedule for the examinations at the top, immediately after point numbers 3 and 4. The schedule for the examinations, maximum marks, pass marks, and other conditions were prescribed in annexure enclosed with the minutes of the meeting. So it was decided in the meeting of the examination conducting body what should be the pass marks, and then notified for examination.
What was the stand of anything else you want to show?
No, that's not. This is the factual position. But on legal principle, I have to flag 2 issues, 2 points. Number 1.
That you will argue later. What was the ground of dismissal?
Yes, please have a look at the 120. Finally comes to 124.
If you
Paragraph 11.
Can you give us the relevant portion, Mr.?
Yes, page 124, paragraph 11 onwards could be the relevant portion.
Yes.
Kindly take note the sentence of that paragraph, which begins with subsequently due to, the 4th line of paragraph 11. Subsequently due to cadre restructuring. Have your lordship kindly got that?
পুরোটাই পড়ে দাও না 11
ঠিক আছে ফ্যাক্ট এগুলো তো বলা হয়ে গেছে এগুলো পড়া যাবে।
Yes.
Subsequently due to cadre restructuring, the LDCs, UDCs and data entry operators grade A were clubbed together and named as tax assistant and upper division clerk with special pay, and tax assistant and data entry operators grade B and C were clubbed together and renamed as senior tax assistant with recruitment rules published by the Central Board of Excise and Customs. These all were done up to 2003, and the applicants appeared from time to time in the departmental examination for promotion for the next higher grade, that is inspector, and a list of successful candidates was also published with the establishment order number so and so dated 30th September 2003. Right. In paper 1 and 3, 40 and 50 are the qualifying marks in paper 2. This examination is a departmental examination for STA which was held in the month of November 2003. By virtue of this, the applicants cleared the departmental examination for promotion to the post of STA, and thereafter, by virtue of different orders, the applicants were promoted to the post of inspector on purely temporary and ad hoc basis in the pay scale of so and so. The said promotion orders are contained in Annexure A2, which are dated 15/5/2006 and 16/5/2006, and as per clause 3 of the said order, their ad hoc promotion will now not bestow on them any right to claim seniority in the cadre of inspector. Apart from this, the clause 1 of the said order also reads as under: they will not be allowed to claim seniority over direct recruit candidates who are likely to be appointed as inspector in due course against their respective quota. The clause 4 of the said order provides as under. Since their promotion is purely temporary and on ad hoc basis, they are to undertake that they have no objection to accept promotion as inspector on purely ad hoc basis and consequential reversion to the substantive post on STA whenever the administration deems so necessary.
Then
the respondents have also issued an order on 7/11/2017 wherein 13 senior tax assistants of the customs house were promoted to the post of inspector preventive on purely temporary and ad hoc basis in the pay scale of so and so. And this order was directed to remain subject to final outcome of OA number 880 of 2007. The respondents thereafter issued a seniority list of senior tax assistant as on 2007. The respondents subsequently issued circular of 2009, and this circular was issued on 1st December 2009, not the circular that I placed. The said circular is governing the field of departmental examination of ministerial officers to the grade of senior tax assistant in grade C. The bare perusal of establishment order number 378 dated 30th September 2003 is clear to the extent that the same is the result of departmental examination for STA held in the month of November 2003, and all the applicants were declared promoted to the post of STA. Subsequently, the orders of 2006 and 7, which in regard to the temporary and ad hoc promotion to the post of inspector, now the claim of the applicant cannot be accepted at this juncture that they were promoted to the post of inspector with effect from 2006. As such, they are not supposed to reappear in the examination. As indicated above, the said promotion orders are purely temporary and ad hoc basis. And the said order also provides that the applicants will not claim seniority in the cadre of inspectors. Not ad hocism for the purpose of seniority is quite different from ad hocism for the purpose of promotion. The Learned Council has also relied upon a notification of July 1998, and as per Rule 4C of the notification requires the qualifying marks for the post of inspector is 40% marks in each paper. But the covering letter of the said notification also says that the draft notification rules and syllabus for the departmental examination of the officers and staff in Central Excise Department. The Learned Council relied, not pausing here for a moment, your lordships know, not in Kolkata Municipal Corporation, there is nothing but draft service rules. Today, the corporation cannot say that since it is a draft service rule, I will not act on this. It's going on from 1992. The Learned Council relied upon a circular of 2008, that 20th August 2004. And as per the said circular, it is pointed out that for examination for senior tax assistant, the minimum qualifying marks for paper 1 and 3 is 40% and for paper 2 is 50%. And the said notification also says that examination for inspectors in Central Excise, the minimum qualifying marks for paper 1 and 3 is 65% and for paper 2 is 50%. The Learned Council for the respondents also raised upon the recruitment rules of 2002, which clearly provides for promotion to the post of inspector, and as per note 2 it is mentioned, candidates shall be required to pass such written test as may be determined by the central board from time to time. As stated above, the bare perusal of the order of 30th December 2006, it is clear to the extent that the same is the result of the departmental examination of STA, whereas the another order is promotion order to the post of inspector on purely temporary and ad hoc basis. As such, it cannot be said that the applicants were promoted on regular basis to the post of inspector and they can be given any exemption from appearing in the departmental examination for the post of inspector, and there appears to be no illegality in the order of 1st December 2009. As such, we are not inclined to interfere with the present way and the same stands dismissed. So, why this 2nd August 2004 order or this memo should not be acted upon has been rested on the sole ground that our promotion was on ad hoc basis. But the fact remains that while we undertook this promotional exercise, this 2nd August 2004 was not brought into force.
Mr. Mojumdar, kindly come to page 125.
My lord.
Place paragraph 12.
The clause 4 says,
yes, that
since their promotion is purely temporary and on ad hoc basis, they are to undertake that they have no objection to accept promotion as inspector on purely ad hoc basis and consequential reversion to the substantive post.
Whenever the admission.
Of course not, I am not found fit for the promotional post. I undertake to be reverted back.
You are not fit because as per their rules, you have to secure 65.
That's the question. But the rules did not prescribe for a minimum qualifying marks as in the higher post.
That we will hear them. what they
20th August 2004 is the sole hurdle.
Sole hurdle.
That hurdle was not brought into the playing field when the game was on.
Also, when the expert body says that it has no
It has no retrospective effect. And we in our this meeting, committee meeting or core meeting, decided the cutoff marks. That's page 270. The rules do not provide for any cutoff marks.
The rules, please, will you take us back to the rules once more?
Yes. Please see page 120, that was page 186.
1998.
186.
Take only
Page 15, yeah, para 15, page 126.
126. Candidates shall be required to pass such written test as may be determined by the Central Board of Excise and Customs from time to time.
Para 15, para 15. Learned Council also.
Relied upon a notification of July 1998.
1998.
Yes.
As per Rule 4C of the degree, qualifying marks 40%.
40%.
সেটাও যেন হয়ে গেছে। এবার বলছে সেটা আমি এটা নেব না যেহেতু it is a draft notification. Where is that July 98?
14th August 1998.
July 1998, which is that paragraph 15, this Learned Council relied upon.
No, that is page 101 and 102. That is probably dated August 1998, not July. 101 and 102.
Which you,
There you go. It's 102.
Please see page 101 first. Clause 3. Officers who will be required to pass the examination. Every direct recruit appointed to a permanent post or a temporary post is likely to continue. No, this is for direct recruit. Please see the next page, 102. Rule 4, qualifying marks. The qualifying marks for passing the departmental examination will be as under. Please see clause C. Inspector grade 40% of the total marks in each paper. But in the meeting of Nesen, the examination.
Selection process started in 2003. Then clarification notice of 2004 has not come. ওদের সাথে তো জন্মই না মেবি ওদের ট্রাফিক কেস যদি বিভাজিত যদি বিভাজিত রিভার্সালের কন্ডিশনটাই যেটা রিভার্স করেছে সেটা তো তুমি সেটা বেসিসটাই যদি না থেকে থাকে তাহলে তুমি ক্লারিফাই করে নতুন কন্ডিশন ঢুকাবে। অলরাইট, yes, anything else?
I'm not. So the rules spoke of 40%. Maybe the examination conducting body while carrying out this exercise had decided to raise the bar up to 50%. But when we took the examination, we knew the bar to be 50%. And thereafter we passed. And please see page, recollect page 270. The examination conducting body said that we don't mark it as such, we mark it as passed or failed. So a conscious decision taken through the limb of the government had led to a conclusion of having these persons declared to be passed.
That means they have secured 40%.
Bar of 40% was raised to 50%, we crossed the bar.
Yes, who is for union of?
I'm not the sole legal issue is.
Yeah, just one. Yes, you finish it. Just one. Yes. So you please sum up your argument.
My lord, 3 points in submission.
It was for a specific purpose
My lord.
and was not applied.
Secondly,
Hmm.
not secondly, my lord, this is a corollary to the first point. My lord, it amounts to, my lord, shifting of the goalpost. My lord, as your lordships have phrased this term. Shifting of goalpost after commencement of the game.
That special bench is still pending. In Supreme Court, it was referred by the.
Yes. There was one differing judgment which was referred to the.
Yes, yes. No final outcome.
No final outcome.
Yes.
Then not the second point would be in our case that 2004, 20th August 2004, at the most is an administrative decision. At the most.
Cannot override the rules. Draft notification.
Draft notification.
Yes.
And it also cannot have a retroactive effect. I don't say it's a retrospective effect. The respondents were wrong in coining it as a retrospective action. It's a retroactive action. Because it takes away an accrued right. The difference between retrospectivity in legislation and retrospectivity in administrative action is this. A legislation can always have a retrospective effect. But an administrative action cannot have a retrospective effect if it takes away a right. It can have a retrospective effect only if it confers certain right. Say, for example, the MACP, the promotional rules. Administrative action can only have a retrospective effect if it confers certain rights.
In legislative act also, it has to be specified that it is having an effect from that.
Yes, it has to be specifically mentioned in the legislation.
Yes.
But not, it's an administrative action, not a legislative action.
But ad hocism can give rise to an accrued right, Mr. Majumdar.
But I have passed the examination. That is a final conclusion.
But still you have been designated
as an ad hoc inspector, maybe for, please see the special condition mentioned in it. I cannot claim seniority and I undertake to reversion. Probably some seniority issue was there. But not the action was complete with my passing the examination.
Yes.
Thirdly, this cannot be raised to the stage of a dormant law even. 20th August 2004 cannot be, first of all, it is not a law. Therefore, the question of this law remaining dormant does not arise.
Yes.
And the learned tribunal proceeded on a completely wrong direction. Since we were promoted on ad hoc basis, therefore the 20th August 2004 is right. That's not the logic. Can't be the logic. We are challenging the 20th August 2000, the action flowing from 20th August 2004 on several grounds. This cannot be applied retrospectively, number one, or retroactively, number one. And number two, this has already ended in a finalized process. There is a result arising out of this exercise. And the examination conducting body and the board both may not intersay themselves. They say that 2004 was a one-time exercise, and this cannot have a retrospective effect. And we ourselves frame the cutoff marks. That's page 270.
Can you please give us page 126? This Para 15, that is July 98, is page 102.
That's 102.
Now, next paragraph, 20th of August 2004. This is which page you said?
20th August 2004 is page 48 of the paper book.
48. Very good. And next paragraph, 29 November 2002.
That's that draft rules, page 102, 2002 rules.
That is page?
It begins at page 186 probably.
Page 186.
186.
Page 186. And the order of 30th December 2006, para 18.
30th December 2006.
The bare perusal of the order dated 30th December, it is clear to the extent that the same is a result.
Should be 30th December 2003. Can't be 2006.
No, must be 2003.
30th December 2000?
Should be 2003.
It is written.
See, Milord, it is 26.
Oh, sorry, 30th of December 2006. See, 186 is lost কোথায় ঢুকিয়েছে, no?
It should be 30th December 2003.
Page 26.
Because we were all STA by 2003.
This is page
26.
26.
2003 too. This is a wrong recording in the order of the tribunal.
And this paragraph 17, note 2, it is at page 189. That note.
That, yes.
Page 189.
Yes. Page 189. The first sentence of note 2 at 189.
Yes, 26 a qualifying mark here.
26.
উপরে মাত্রা।
এই যে 30th of December 2003
তে এনাদের পরীক্ষা ছিল 47
হ্যাঁ 2003
2003
ST এর সময় ST এর সময় এটা ছিল সেটা মনে আছে
একটা টাইপ পরীক্ষা
ফাইনালি ও রিক্রুটমেন্ট 30/11/2002 এর উপর রিলাই করে পেজ 187 টা দেখো 186 এইখানে কাট অফ মার্কের কথা কিছু বলছে ঠিক আছে এখানে সাবজেক্ট টু ইয়ে করেছে পেজ 186 নোটটা হচ্ছে 189 এজটা বলছে এখানে কিন্তু will be required to pass such written examination এই প্রথম পোর্শনটা করে দিচ্ছে টাইম টু টাইম এই নোটটাতে যেটা পেজ 26 এর মার্কস বলছো না সেটা এখানে এই নোটটা হচ্ছে নোটিফিকেশন অফ 29 নভেম্বর 2000 নোটটা অ্যাটেন্ড করেছে তো সিনিয়র ট্যাক্স অ্যাসিস্ট্যান্ট আপার ডিভিশন ক্লার্ক ট্যাক্স অ্যাসিস্ট্যান্ট সবকে ক্রাফট করে নোটে কিন্তু এখানে কোয়ালিফাইং মার্কস কোনো কোয়ালিফাইং যেটা তোমার আছে ওখানে পরীক্ষা যখন নিয়েছে পেজ 26 পেজ 26 এর 2003 তখন তো সার্কুলারটা বর্নিং জন্মায়নি
এইটা নিল 98 সার্কুলার
58 রুলটা এখানে ছিল তো where is the 98 rule
that 98 rule, yes. So that is at page 101.
Yes, teacher. Yeah.
Begins at 100. And please see page 108. 108 says that at 108 note 2 of that rules, this is a special rule for examination. This is a special rule for examination. Please see the caption of these rules. These rules may be called the Departmental Examination Central Excise Rules 1998. Now kindly comes to page 108.
102
देखिए जाएगा Note 2 of that page, but just above the instructions of guidance. In declaring the result, the marks obtained by the candidate should not be communicated to them. The result should be announced by indicating separately the names of the candidate who have passed the examination and those who have passed the examination in part. Please reconcile these rules with page 270, that is in essence explanation. 270.
No, if this is page 100 is the 98 rules.
Yes. But 186 is not the recruitment rules.
That is of 2002.
Recruitment rules, not vis-a-vis the recruitment rules and the examination conducting rules. Examination conducted rules are special insofar as the facts are concerned. Recruitment rules will provide for the percentage of promotion or the direct recruit, all these things, what is the qualification, etc. But so far as examination is concerned, the rule at page 100 is the governing rule.
But recruitment rule do not specify also the percentage.
It does not specify. So what is specified is in the examination rules, which is at 100, at 102, it does not disclose the rules and that is the marks, and that is why at 270, Nation specifically referred to this and said that we do not disclose the marks. We say only who has passed and who has failed. 270.
And admittedly the petitioners have passed that ওরা নিজেরাই communicate করে বলছে.
Any judgment here?
No, not this. No, sir.
Yes.
Yes, Mr. We know, we said on that date, we gave time on that. It's very difficult for us because we don't know how long this bench will continue.
Any day, any day on the next week, kindly, my lord. Any day on the next week, my lord.
You kindly consider they sit for examination for getting promotion in 2003.
My lord.
At that time, 1998 recruitment rules was in prevailing. In 2003, you passed the establishment order or examination rule where you fixed that for paper 1 and paper 3, their qualifying marks would be 40 and paper 2 50. But no result would be communicated to them. You published a list saying they have passed, you have given promotion on ad hoc basis. Now you made a clarificatory order in 2004, you giving effect to them. Now they are challenging that this clarificatory order is not applicable to us. You say, what is your stand on this issue?
My lord, as I have understood, as on date, my lord, subject to clarification, my lord, they have been, my lord, passed the examination for senior tax assistant. And they have been given promotion to the inspector on ad hoc basis, my lord, a purely temporary basis. Well, ad hoc promotion has no right, my lord, no fundamental right to be regularized, my lord, unless they have, my lord, passed the departmental examination, regular departmental examination. Well, senior, they have been promoted to senior tax assistant, but they have.
That was in 2003.
See, now, my lord.
2005 to 7, they were appointed as inspectors.
On ad hoc basis, well, not any examination. I can appreciate, my lord. Two things are there.
What are the attributes of ad hocism? Tell us.
Well, ad hoc is for the purpose of, for the exigencies of the work. They have been giving ad hoc. For the exigency of the work, in the department, they have been giving promotion on undertaking. They will not create any. They will not but ask for.
So show us the decision of yours. Show us the decision of yours that this on the basis of this adhocism you cannot claim regularization. Par contra, you are saying that we are giving you such because you will not claim any seniority.
But that is what is there in the record. I cannot go beyond the record, my lord.
Right.
Only thing, my lord, I am telling you, lordship, my lord.
Yes.
In general parlance, ad hoc cannot create any right, my lord, to be regularized or to be promoted, my lord, unless he, my lord, complete the departmental examination. That is my first issue, my lord. Second issue, my lord, what my learned friend is saying here, my lord, the rules given by the, my lord, central government for departmental promotion, my lord, the department has the authority, my lord, to modify the rules as and when it is necessary, my lord. That is there in order itself. Impugn order categorically stated in page, my lord, your lordship sees, my lord, that page 124 probably. Sorry, my lord, my lord, page, my lord, 126 para 17.
Yes.
There it has been categorically stated, my lord, the candidate shall be required to pass such written test as may be determined by the Central Board of Excise and Customs from time to time. Therefore, my lord, the board has the authority to, my lord, make any cut-off marks to be passed by them by a regular departmental examination for promotion to the inspector.
There is no dispute. You have the authority.
Now, what is his case, my lord? The printer's case.
Just pause there for a moment. This rider which you are reading, this is in the recruitment rules.
Yes.
It does not specify any qualifying marks. It only says that you have to be within 45 to 47. This is the condition, note 2. But when we shift to the rule for examination, the rule for examination says that this will be the procedure. Rule for examination, kindly come to this rule which has been just now pointed out.
Page 100.
101. 101. This is the departmental examination central excise rules. Page 100 and 102. For inspector grade, you specifying the qualifying marks to be 40%, which they have secured. Yes,
My lord, it was in 1998, my lord. The rules is 1998. But I think, my lord, there is subsequent changes in October 2003, my lord.
October 2003. October 2003 was
One minute, my lord.
Are you talking about page 219?
My lord, in, my lord, 16th October 2003, my lord.
Yes.
NACN issued a circular, my lord.
Page 219.
Well, there, my lord, the marks were given in customs with book 65%, allied was 50%.
To conduct next departmental exam.
No, no. এখানে করে দিলে পোস্ট অফিস দিয়ে সিনিয়র আছে 26টা হচ্ছে রেজিস্ট্রি নাই তো রেজিস্ট্রি সিনিয়র ট্যাক্স অফিস 15 করে পাঠক করছে সিনিয়র ট্যাক্স অ্যাসিস্ট্যান্ট এটা কিন্তু সিনিয়র ট্যাক্স নেক্সট দিয়ে এইটা দেখুন
তা 2003-এ সার্কুলার বানানো। দেখে বোঝা
which was restructured as senior tax. So
Initially, my lord, there was a post of tax assistant.
LDC to UDC was in 2003.
That was prior to 2003.
So in that you appeared in one written test.
And became STA by reason of upgradation. That also required certain knowledge to be.
After that you appeared in the next written exam. Now kindly come to page 102.
102.
So we in from tax assistant to the senior tax assistant, this upgradation.
Upgraded.
That was not through any written test.
But there was redesignation of posts.
But what Mr. Bhattacharya is citing, page 219.
219.
Yes.
Page 26. Mr. Mondar, kindly come to, I am coming to your page 221 for our clarification. Page 26, it is result of the custom departmental examination for STA, senior tax assistant held in the month of November, which date 27, 28 and 27 and 29. That is senior tax assistant.
Right.
So for appearing
Now
for
they come to
post of
page-
senior,
Because by that time, that post has been redesignated as STA.
Now your name Tapos Aditya, name of Tapos Aditya is appearing in this list. It is serial number 31,
My
page
lord.
27.
My lord.
He has passed.
My lord.
Which examination? For
STA.
STA. Now page 221.
no, that is in fact from LDC to UDC. This page 26 was thus from LDC to UDC or
Yes.
from tax assistant to senior
My lord,
tax assistant.
may I clarify?
These tax assistants, senior tax assistants are redesigned posts. STA is a redesignated post.
Very good, but this examination was for STA.
STA. That is in the UDC cadre.
Like LDC restructuring as my lord, tax assistant. Then UDC restructuring as senior tax assistant. Then they, my lord, participate in the examination for promotion to STA, senior tax assistant. And they
Lord, has
have
that
been given ad hoc promotion for
short list of dates, that list of dates along with that compilation. Please take that list of dates.
Oh.
That is my case. But as case is there, I cannot develop what is there. That I have.
This is the last entry on the first page.
They have passed the
2001.
departmental examination for senior tax.
Come back. Yes,
19 July 2001. Cadre restructuring took place. Redesignation of posts of LDC, UDC and data entry operators grade A. Clubbed as tax should be tax assistant. Second page টা আমারটাতে নেই, যা যেটাতে আছে আশা করি দেয়। কোনটা বলো? Second page টা আমারটাতে
The
নেই।
applicants then working as data entry operators were redesignated as STA. Then if that is so,
Yes.
then why you are appearing in a departmental examination for STA?
We were promoted to this already. This is LDC to UDC. Now they are identifying this post on redesignation.
No.
LDC to UDC, we had to undertake an examination. We had to go through an examination.
This page 26
Yes.
is from STA to inspector. It is not from STA.
No. This is LDC to UDC.
For being STA.
Not the examination for its inspector was between 2005 to 7. 4 to 6.
না সেটা কিন্তু সিনিয়র ট্যাক্স অফিসার হবার জন্য পরীক্ষাটা হচ্ছে, নট ফর ইন্সপেক্টর। ওটা দিয়েছে
Promotion to the post of inspector.
হ্যাঁ, ওটা দিয়েছে, ওটা
এইটাই
উইদাউট
কিন্তু
টেকিং এক্সামিনেশন।
Subject to appear in তারপরেই তো দুটো এক্সাম হয়েছে, একটা হচ্ছে from LDC to UDC, UDC টা রিস্ট্রাকচার হলো ট্যাক্স আর
এইখানে রিস্ট্রাকচার কবে হলো?
এই যে
রিস্ট্রাকচার হলো হচ্ছে 2021, পরীক্ষা হচ্ছে 2003 পরীক্ষা হচ্ছে 2003।
original LBC structure post under সেই পরীক্ষা দিয়ে following tax যেটা তুমি বললে যে ওর নামটা কোথায়, এই যে appear held on 13th for promotion is a qualified যে
2005 পরীক্ষা তখন কত? তখন কিন্তু 4-এর এরিয়াতে এসে গেছে। আজকে যদি পরীক্ষা হয় এরিয়া 2004-তে এসে গেছে।
জাস্ট এই দুটো পাস একটা হচ্ছে 26 রেজাল্ট অফ এসটি হেল্ড ইন মান্থ ডিসেম্বর 2003 না সেখানে আমাদের কয়েকজনের নাম আছে।
You appeared in examination for being STA in 2003.
Let us put it there.
Yes.
Very
And for being inspector in 2005.
4 to 6.
এটা তাহলে কি এটা এখানে তো তাপস বাগচি নাম
5 to 7. Yes.
Is it correct?
Yes. Yes.
So when you are appearing in an examination held for giving promotion to the post of inspector, then the clarificatory order of 2004 has come.
Had come, but they did not apply this. That was my case. They had not applied this in the exercise. And when it came to the interdepartmental clarificatory exercise, Nassen said, no, we did not mention this because we thought this was a one-time dispensation of 2004. And then with reference to the rules, it said that 40% is the cut-off marks.
This affirmation of yours that it was not applied,
yes,
that must have been pleaded in your petition.
Please come to me at page 17. Page 16.
No, that is the original application.
That's the original application, of course.
Sorry. Page
16. The first paragraph gives the dates on which we were promoted to the rank of inspector. Then the applicant stated that the applicants were thereafter selected for the post of inspector and were promoted to the said post in 2006-07. Your applicant stated a seniority list was published on 31st August 2007 in the post of senior tax assistant in the regular post effected from so and so. The applicant stated the applicants had been serving for the last 3 to 4 years in the post of inspector since 2006-07, and all on a sudden the applicants were shocked and surprised to note the establishment circular of 1/12/2009 on the basis of a purported circular of 20th August 2004 of the Ministry of Finance, whereby it has been directed that the officers who have got promotion to the grade of inspector with less than 65% in the departmental examination for promotion from LDC to UDC have to qualify in paper 1 and 2 with requisite marks in the instant examination to be held on 27th of January 2010. In the said establishment circular, it has also been threatened that this is the only and final chance, otherwise so and so. The applicant stated that the applicants passed the above examination in the year between 91 to 2003 and got promotion to the post of inspector in the year 2006 and 7. That prior to the issuance of the impugned circular of 2004, the applicants had passed the customs departmental examination in all the 3 papers with requisite qualified marks for senior tax assistant, and as a result of which the applicants were promoted to the post of inspector. Even after joining as inspector, the department did not point out in any manner whatsoever till 1st December 2009, when the aforesaid circular of 2009 was issued, that the applicants did not qualify in paper 1 and 2.
1st December 2009 is at page
47.
That's 47.
Paragraph 17 টা পড়ো, page 19.
No, not.
Then not page 19, paragraph 17. The respondents did neither publish any circular nor intimate anybody till 1st December 2009 that minimum 65% marks were required in the departmental examination. Now, please visualize the situation. There are rules which provide for 40% cutoff marks. The examination conducting body say, no, we don't disclose mark. We only keep it with ourselves. That will be the percentage of marks, and we mention this in the examination meeting. So when the examination is notified, we come to know that 50% is the cutoff marks. And we pass with this bar raised in front of us. And then after 3 years, we come to know that no, you have to take this examination once again, because sometimes in 2004, we decided, although we have not given effect to this.
You come to page 221.
221. Yes.
National Academy of Custom Exercise and Narcotics.
Please see page 21. This is a continuation of page 219.
Yes.
Please see, confidential.
ইন্সপেক্টরের জন্য হচ্ছে 65, 50, 65।
221, the date of examination is given, Mr. Mujumdar.
Note, tax assistants on the restructured cadre who have passed in any of the above papers in any of the departmental examination had earlier are exempt from appearing in this paper. And in the case of DEOs, those who have already passed any of the examination in computer are exempt from appearing in paper 2.
Annexure 1 at the top, this is examination for inspectors in
Yes, yes.
You participated in these examinations.
I participated after, say, 2005 to 7.
I participated in this examination and I passed.
With 2004 থেকে 5, 5 থেকে 7 হয়েছে, not in this examination.
This is when from LDC to UDC.
This is UDC to inspector.
Uh-huh.
This is UDC to inspector.
No, no. This is of 2003.
Yes, examination for inspectors.
Your first promotion,
Was LDC to UDC.
Yes, that was in 2003.
3.
That is
Prior to 2003, yes.
221 is 2003. Next, in 2005 to 7.
In 2003, we did not pass any examination as such. We had passed from, yes, we were upgraded to this STA.
But what do you say about this circular, Mr. Mujumdar?
Which circular?
16th of October 2003, 219.
Page 219.
Huh.
Please see what is this. First caption is confidential. Then to all chief commissioners. Then in accordance with the letter of so and so, the Director General Nesen, it has been decided to conduct the next departmental examination for promotion for ministerial officers to the grade of inspector and STA in Central Excise Department and to the grade of preventive officers and examiners in Customs Department during the month of November 2003.
That is November 2003, you appeared.
I appeared for inspectors between 2005 to 7.
Yes. But LDC to UDC, that was...
No, LDC to UDC, that was much earlier.
Much earlier.
That is what you submitted just now.
No, by STA was a post which had been upgraded from tax assistant on UDC.
I understand that. So from LDC to UDC, restructured as senior tax and tax. For passing that hurdle, you appeared in one test. That was in 2003.
No.
Is that your contention?
Yes, ma'am. My lord, if your lordship kindly see the page 222, 222.
Yes. Your name features there.
I'll just show to your lordship.
Well, the result of the Customs Department examination for STA held in the month of November 2003 is furnished below. Then 3, 1, 2 papers are given. Then, my lord, kindly turn the page. Kindly come to serial number 31, Tapabrata.
Yes. Get it.
Therefore, he has been promoted to STA, my lord. Examination held only for the STA in 2003.
Right.
কবে হয়েছে
Therefore,
কবে কবে এসে হয়েছে সেটা date হবে এখানে।
see the qualifying mark. 40, 40.
Then, my lord, then in STA it is okay. It is quite correct, my lord. Now, regarding in October 2003, there other marks have been given in 65 marks. I have just, your lordship has seen the circular of NACN.
30th December is the circular at page 26 only. You have annexed. Yeah, this is qualifying marks in 2004.
If any test was held in 2005,
yes,
in which they appear,
yes,
any examination?
My lord, I will answer next day, my lord. Today I can't give this answer.
No, please see page 237. 237. We were called for interview.
No, who qualified in physical test? For promotion to the
Eta.
physical test. Any written test was held. It is held physical test. Physical test, that is measurement of what.
The next that was page 247. এটা কোনো পরীক্ষা না, এটা
They have found five hours test was
written পরীক্ষা দিয়েছেন হ্যাঁ কি
in 2007.
এই হায়ার গ্রেডের পরীক্ষা তো হচ্ছে 2003, যেটা রেজাল্ট ছিল না, সব টিপি করে দেখানো হয়েছে, যেটা আপনি যেখানে টিপি করে সব দেখানো হচ্ছে।
There was no written test.
No, my lord, it is, they have been given only, my lord, exigencies of the work, my lord. Department needs the person.
Show us that there was no written test.
Let them satisfy, your lordship. It is their case. They will have to satisfy that there was written test and they qualify.
We understand.
We are all trying to find out the fact.
My lord, according to me, my lord, they have been given only, my lord, ad hoc promotion to the inspector. There was no examination conducted for promotion to the inspector.
Where have you stated that in your reply before?
My opposition is clear, my opposition. I have stated everything. If you lord, my lord, kindly take some my opposition then.
Wait.
Five hours test was held. Five hours and physical.
Five hours and PET, yes.
Written test.
That was the one which was there previously, prior to 2003.
I'm a senior tax assistant.
May I
just your lordships were querying on page 26. Please come to 211. Please take 2 pages side by side. Page 26 and 211 side by side.
Same.
No,
please see, no,
not same.
Please see page 26. 30th December 2003.
And page
211.
211.
Yes.
17th July 2003.
এটাকে পুরোটা পড়াও।
In pursuance of the ministry's number so and so dated 19 July 2001, dated 5/6/2002, then there are several numbers, and consequent upon the GSR number 21/2003 of the Government of India, the following existing officers in the grade of data entry operator grade C, tax assistants,
data entry
operator grade P, UDC special pay are hereby deemed to have been appointed as senior tax assistant in the pay scale with effect from 21/2003.
This is on restructuring.
Accordingly, henceforth the following officers will be designated as senior tax assistant.
Redesignation.
So the test was given earlier. Restructurization led to redesignation with effect from 21/2003.
So you appeared in only one written test.
One written test, one.
রিটেন টেস্টে সেই আইন অনুযায়ী এই যে এইখানটা এবার অ্যাপ্লাই করবে। এই লোয়ার গ্রেডে আমরা পাস করে গেছিলাম কোয়ালিফাইং মার্কস নিয়ে, সেই জন্য আমাকে আর নতুন করে পরীক্ষাটা দিতে হচ্ছে না। পেজ 49 এইটা অনুযায়ী আমাকে পরীক্ষাটা দিতে হবে না, কারণ আমি লোয়ার গ্রেডে পাস করে গেছি। তাই তো?
Yes, sir. I'm the higher.
So the dispute is that in that written test, having secured the appropriate marks, whether they can apply the 2004 circular round. This is the issue.
Yes. 2009,
2004.
page 47, page 47. Just in, my lord, I'm appearing for the interveners. Just page 47, kindly sees. Read this with 48. 2004 is 48.
Yes.
You know, 2007, page 47 is 1st December 2009, which was the circular impugned in the original application. This was the decision under challenge. What were the, Mr. My senior has read it, Milord. From apart to the last is the issue under challenge. Milord, what is under challenge? Kindly sees. Apart, it is seen from the records that after 20th August 2004, that is page 48, some officers have been promoted to the grade of inspector, PO, EO, without qualifying in paper 1 and paper 3 with requisite marks of 65%, which is required in ministry's data dated 20th August 2004. And the said officer should also apply in the prescribed form. Since we were never informed about this 65%, we were already on ad hoc. We were asked to appear in this examination, which was scheduled on 4th of December 2009. And therefore, the officers concerned, they rushed to the tribunal, Mr. Mojumdar's clients. What is in the italized form, what is written, kindly sees. It is hereby clarified that those officers who have got promotion to the grade of inspector with less than 65% marks.
Where was that examination for the
LDC to UDC
designated post of senior tax assistant to the post of inspector?
Now, my lord, I have
no written test.
No written. With respect, but please take the trouble.
No, we will take the trouble, but satisfy us point-wise.
But there was a written test in the month of September 2004 for inspector. That is, my lord, page 538, where, my lord, everything is written and we have been shown as passed. Page 538 is a document, is their document, government of Office of the Commissioner of Customs document. There are, this is volume 2, yes.
Volume 2 to the.
Now, this is a part of.
Mr. Bhattacharya, from UDC, from LDC to UDC, there was a written test.
My lord.
From senior tax assistant, which is a restructured post of UDC,
my lord,
the post of inspector, there was no written test.
No written test because the papers were common, and if that is that page 48 circular.
Yes. Papers were, but in the lower grade we have passed. Well, with the qualifying marks prevalent then. The requalified marks or the fresh qualified marks was changed later, by which we have already passed.
LDC to UDC পাস করতে গিয়ে যদি কেউ কাস্টমসে 65% পায়, তাকে সে এমনি ইন্সপেক্টর হবে।
দাদা, এসব আবার পক্ষ করবেন না প্লিজ, আপনাদের আবেগের কথা শুনুন প্লিজ। এই ফ্যাক্টর কি এটা পরীক্ষা হয়েছিল সেপ্টেম্বর 2004 এ? Result of the examination for promotion for the post of inspector EOPO held in the month of September 2004. দাদা, এখানে আপনি তো আগের দিন এটাই দেখালেন না।
Mr. Bhattacharya, what are the admitted facts? In 2003 and prior there.
26.
For getting the restructured post of UDC.
আমাকে দেখাতে বললেন তো এটা।
So first, when they appeared in that, they did not secure 60.
Now they don't know.
Because there was a condition in your examination that marks need not be published.
Only past
B
has been given.
So they appeared. Now after that you have SCA to inspector, you have conducted physical verification test and violence. Now after doing so in 2005 to 2009, you relied upon the circular of 2004, creating a new condition for Yes, when they held the test in 2003, there was no condition that 65 is required. First time it was born is 2004.
My lord, 2003, there was no such examination held regarding the petitioner's here, my lord, for promotion to the inspector. No written test has been done.
They have only crossed one written exam.
That is for senior tax assistant.
Yes.
Therefore, my lord, what is the petitioner's case? That since we have secured the pass marks, that is 40% and 50%, whatever it may. Therefore, I need not to given any examination for promotion to the inspector.
No, there
Because
was no
the
provision for in written test.
Written test. Now, question is that in 2004, the circular has been came. Then, my lord, for promotion, the inspector, they need to sit for departmental examination because the promotion has been given to them on ad hoc basis for exigencies of the departmental work.
They have covered that, Mr. Bhattacharya. They have appeared in the physical efficiency test as well as viva.
But there is no written test, my lord.
Written test.
No,
there was no condition also.
Well, on that date, my lord, in October 2003, the marks has been given in paper 1, 2, 3. There are 65, 40, and 50. Your lordship kindly see the circular has your lordship seen.
Yes.
Therefore, my lord, he need to, in a case where he qualified less mark.
Yes.
If I come to the circular, then my lord, he will have to sit for again.
Oh, that is what he is challenging.
He challenging no, since we have, but that is my lord, only thing I
suppose you tell me that sir, you appeared in the written test, you have to pass. How you will pass, that is not known to me, that is up to the employer. I sit, I pass. You give me the post of STA. Next, when I go from STA to inspector, in maximum cases, promotion or direct entry, there is a period of probation or there is a period of ad hocism. Why? Because the employer has the right to impose further conditions if necessary. Now, your contention 2004, you are saying that if in the examination which you have already passed, you had not secured 65, now I am insisting that you have to take that examination across. This is the issue. Whether you can do so or not. You are the employer, you can do many things, but you are a statutory authority, you have to act in terms of the statute. Show us that provision is there, empowering you,
my lord,
empowering you to give retrospective effect to a decision, which your expert body has also said that no such retrospectiveness can be given. Our question is that if you show us that this 2004 circular is sacrosanct, it will be appearing, it will be effective since 2002 only. They have no right.
But my lord, here
Tribunal has proceeded on the basis of your argument that ad hocism does not give rise to any regularization or permanency, because that is always subject to the employer's privilege. So for that, they in fact have sacrificed their seniority. Now they are old people. Now if you say that in 2024, that Mr. Bhattacharya kindly consider.
And at that time, you have not stated so. You have taken just physical test and viva was.
That's why, my lord, in 2009, the circular was given even in 2000, on the basis of 2004, my lord.
Suppose today, Mr. Bhattacharya, you regularize them.
My lord.
Today, hypothetically, you will not be spending any money.
Nothing.
It is also not a case that they would be eating up promotional vacancies because they are there in service. So what prejudice is caused me? Admittedly, they are working. Admittedly, they have appeared in written test. Admittedly, they appeared in viva voce and physical efficiency test. Now you are saying that I am the employer, I will test your competence on the basis of this 2004 appeared in.
But only thing
competency, Mr. Bhattacharya, subject to what you say. You have extracted service from these people. If they were incompetent, you are free to initiate disciplinary. Now the equitable principles come into the picture. Whether, suppose today if they lose, then they will be deprived of their regularization concept. They have to continue ad hoc till their retirement. Or you can pass any other order that if reversion is there,
then departmental review will be made on that is the rule, that is the circular.
That will be a policy decision on your part. But we are asking you that as you are the employer, you show us that statutory provision by virtue of which you could have insisted that you have to secure system.
And the only thing I'm having.
Then we reserve our judgment.
My lord, kindly give me another chance, my lord, in any day. On the next week, my lord, I will answer your lordship query, my lord. Thereafter, your lordship, my lord, pass whatever order your lordship feel, my lord. My lord, only thing I'm hammering to me, my lord, a person, my lord, passed examination, departmental examination for promotion of STA. No, my lord, for the purpose of the department, he has been given ad hoc promotion. And by that time, the circular has come into effect. Now, my lord,
you will wait.
regular tax matter before the Honorable Chief Justice on Friday.
No, Mr. Bhattacharya, we are requesting you since we have heard it, finished it up, please.
If I engage them, kindly bear me for sometimes. My junior will be there. I will come back to your lordship before recess, my lord. I will come back before recess when I answer the question query of your lordship, my lord.
বৃহস্পতিবার না খুব না বৃহস্পতিবার বৃহস্পতিবার ওখানে পিল বেঞ্চ
এখানে আটকে যাবো এখানে পুরো আটকে যাবো
এখানে তো 12 আর 11
আসতেই পারবো পরপর
করতে পারবো নেই মানে
Mr. Mojumdar, learned advocate, appearing for the petitioners, and Mr. Bhattacharya, learned advocate, appearing for the interveners, have concluded their arguments. Due to paucity of time, Mr. Bhattacharya, learned advocate, appeared for all the respondents, Mr. Bhattacharya.
I am appearing for some of the interveners. He is appearing for all the respondents.
I am the respondent.
For the respondents, due to paucity of time, Mr. Bhattacharya, learned advocate, appearing for the respondents, could not conclude his argument. In view thereof, please the matter for further consideration on within বলো Friday কত তারিখ? 9th of February as fixed at 12 noon. As fixed at 12 noon. The matter shall be treated as hardy.
Kindly also record one sentence, one sentence. Appearing for the interveners, I'll be adopting whatever Mr. Mojumdar has said. Apart from that, I don't have any other case because if he sails, I will also sail through.
You are not party before us.
Yes.
You are gone.
I am gone. But I'll be permitted to poke my nose. That is the thing.
Say we have heard Mr. Bhattacharya extensively.
Yes.
We will record that. You are not parties to the
And whatever your lordship feels, at least matter gets over.
We are making
No, kindly do not take it in any other way,
The surname being common, that does not prejudice my client.
Yes.
Surname being common, it will not prejudice him.
Both we are Bhattacharya, they are
whose submission he has adopted, he won't know. Mr. Mojumdar, learned advocate, appearing for the petitioners, has completed his arguments. Mr. Bhattacharya, learned advocate, appearing for the interveners, has adopted such argument as advanced by Mr.
Yes, because this is the case. If he sails, I will also sail soon.
Therefore, due to paucity of
কথা এরকম যখন আমাদের কেসগুলো আটকে যাবে তোমার